Okay, good morning, no? Ang ating pong pag-usapan ngayon, itong basic due diligence and documentation. Now, ang instruction sa akin was only to discuss documentation, no? In the morning, and ako na lang nagdagdag nitong basic due diligence kasi gusto ko itong balik-balikin, no? Para magkaroon po rin tayo ng idea on how to handle our transactions, no? Especially if newbie tayo, no? And this is an additional knowledge for all of you para at least po magkaroon tayo ng how to deal with this kind of transactions, no? So, and yes, this is basic natin na due diligence and documentation. We start first with the basic due diligence. Sa basic due diligence natin, we have to define the meaning ng due diligence, no? Sabi nga natin, ang due diligence, yung investigation or exercise of care that a person is normally expected to do before entering into a real estate sales agreement with the owner. So, parang sinasabi, bago ka magbili ng lupa, mag-imbestiga ka muna. Exercise ka ng due care, no? It is normally expected for us to do this, no? Bili nga tayo ng property, bili tayo ng cellphone, dine-check natin. How about pa yung lupa? Malaki ang presyo, di ba? Mahal siya. So, it is a must sa atin, no? Kasi kapag hindi mo ginawa yan, hindi ka, you are considered as a negligent, no? Wala ka nagkandak ng due diligence, no? Kasi, there are possible instances na merong mga madiscover na mga mali. Sino sisihin mo, kundi sarili mo, no? So, bago po tayo mag-enter ng bentahan or any real estate sales agreement, no, with the owner, contract to sell, assumption of mortgage, and etc., conduct po tayo ng due diligence. Pag hindi po natin masyado maintindihan, punta tayo sa mga practitioners para magtanong tayo. Yan po ang pinaka-basic. The moment that you don't do that, kayo po ang sisihin ko. Okay, so we will start with the basic, no? Kung may bibilihin ka na lupa, ano ba ang dapat gawin? Or ang client mo gusto magbili ng lupa. Of course, you have to know the different kinds of land title muna, no? So, ang mga land title na alam natin, yung mga basic land titles, itong original certificate of title, no? Which is actually composed of several kinds of OCTs, no? Kasi patents ito first time issuance ito ng DNR kung nag-apply ka ng agricultural patent, homestead patent, pre-patent, no? Tapos, pwede rin ding issuance ng court, no? Through a cadastral hearing, no? Nag-file po tayo ng judicial titling, no? Kasi dalawang klase ang titling na first time, no? It's an administrative titling wherein you just file it with the DNR, start ka with the Senro, and then the other one is yung tinatawag nating judicial titling, you file it in court, no? And this kind of titles po, no? Dati, meron ito siyang prohibition wherein hindi mo pwede ibenta ng 5 years. Now, with the recent laws passed, no? It was passed during the time of President Duterte, nawala na po yung prohibitory period. So, any and all patents issued, agricultural patent, pre-patent, and everything, meron po to siyang tinatawag nating non-restriction na. Okay, ibig sabihin, pagka-issue sa inyan, pwede mo na kagad ibenta. However, that meron rin mga patents wherein may nakalagay doon na nag-exercise ang government ng right to use a portion of the property for purposes of easement of right of way. Kaya ang iba kasi nagreklamo, Sir, bakit kami hindi daw bayaran kami ng gobyerno sa road widening? Kasi tingnan natin ang anong klaseng title meron ka. If it is a patent and with that restrictions na naka-state doon na pwedeng gamitin ng gobyerno na hindi ka babayaran, I'm sorry, hindi ka babayaran ng lupa. Pero yung mapananim mo na maputol, babayaran ka noon. Okay? So, let's be clear with that so that you also have to understand that, no? So, now, another kind of land title is itong CLOA, Certificate of Land Ownership Award. Ito yung in-issue sa mga farmer beneficiaries, no, through the Comprehensive Agrarian Reform Program na ibig sabihin, under the principle of social justice sa ating Constitution, wherein you have to give more to those who have less in life, di ba? So, give land to those who are landless. So, yung mga malaking mga landlords sa maraming mga lupa, after getting the retentions, ipag-distribute ang sobra noon sa mga farmer beneficiaries, those who are qualified, no, by the DAR, no? Now, ano ang difference ng itong original certificate of title at CLOA? Bakit itong CLOA, di ba, alam natin may 10-year prohibition yan siya, within which na hindi mo pwedeng ibenta from the time of issuance, no? Now, except that nagsimula ito sa collective title, gaya na sabi ko kahapon, and after that, ni-segregate, pagkatapos na-issuean ka na ng title, ang counting po ng 10-year prohibition natin, doon po sa, from the issuance of this, tawag nating collective title, not yung sa segregated or individual title ninyo, no? So, by that, pwede na pong ibenta. Now, itong stricto po itong prohibition na ito, baka kasi akala laruin ninyo ba, wherein you will just sige, gawan na natin ng contract or promissory note na after 10 years ibenta sa akin, or gawin natin ng lease agreement with option to buy after 10 years, no? Or may iba gumagawa ng real estate mortgage with option to buy after 10 years. Lahat po ng provisions na yan, lahat po ng contract na yan, void po yan. Anything that you do within the 10-year period, hindi po pwede talaga. No. It would be considered as void, no? Kahit na later on makagawa ng deed of sale at malipat ang title sa iyo. There is a certain case that I would like to discuss briefly, wherein the heirs, no, later on question the sale made by their parents with a promise in the middle of the 10-year period na, sige, after 10 years, maggawa kami ng deed of sale sa inyo, bayaran nyo na kami ngayon. And when the parents died, the heirs question it after how many years, no? And sabi ng kabila, hindi ka naman question kasi prescribed na, tapos na, nalipat ng title sa akin, at saka tagal na ng panahon. At so, ngayon, grabe ng development ko. Natalo yung mga heirs, no? Yung mga anak sa sa RTC, Court of Appeals. Pagdating sa Supreme Court, sabi ng Supreme Court, no. The fact that you made a promise within the 10-year prohibitory period at nangyari ang sale after that, na ang source ng sale is that promise within the prohibitory period, yung sale na yan, void din. Void kasi yung promise, void din yung sale ng gawa. So, balik yan sa heirs. Imagine that. So, binalik po, no? So, be careful with dealing with CLOA. So, you have to check it, no? Kasi baka naman, pagtingin nyo sa title din, 10 years din, dito pwede. Check nyo, baka galing siya sa collective title din. How do you do that? You get a traceback document or traceback title para makita mo kung saan nanggaling yung title na yun. Alright? So, be careful on this, and I hope you clarify this. So, anong difference ng dalawa aside from the prohibition ng 10 years sa CLOA at sa kabila is sa OCT wala ng prohibition? Well, ito pong sa OCT po, dati po itong public land and later on classified as alienable and disposable by the government, either proclamation or law, no? So, and it is classified now as alienable and disposable. Nawala na ito siya sa domain ng public ng ownership ng state, nasa public land, no? Hindi na siya timberland, hindi na siya forest land, everything, no? So with that, kung sino yung nakapossession doon, pwede mag-apply either administrative titling or judicial titling. Now, it will be given by the government coming from a public land, now alienable and disposable, papunta sa nag-apply. Whereas, ito pong CLOA, kaya may prohibition siya. And it is not free, no? May bayad po ito farmer beneficiaries. Kasi doon sa patent application sa DNR, 150 pesos lang po ang gagastusin. Look at my video lecture on this, paano po magpa-title first time, no? But dito po sa CLOA, pag binigay itong ng government sa inyo ng DAR, meron po amortization payment for 30 years ang mga farmer beneficiaries, hindi free. Bakit po? Kasi itong lupa na ito, private land ito, kinuha ito ng gobyerno through expropriation, eminent domain, no? Kunin ko ito kasi sobra-sobra na ang retention limits mo, and we will distribute it to the farmer beneficiaries. So it's originally a private land, kinuha ng government, binayaran ang owner, and then ibibigay ngayon sa farmer beneficiaries. So, ibig sabihin, maniningil din sila kasi nagbayad man si government doon. Alright? So, having said that, you are individually given these titles. It will be amortized. Choice ninyo. 10 years, 20 years, 30 years, or you can pay in cash kung meron ka. Ganun po yan siya, no? And because it is for private use ninyo, gigrant lang namin ito. Bayaran nyo rin. Unlike yung sa road widening na kukuning nila is for public use, so walang singil, no? Sila pang magbayad sa atin. So, we have to be clear with this, no? Kasi maraming nasasemplang dito sa dalawang titles na ito. Now, if you'll notice, it's still orange color. Why? Because it is a first-time issuance, no? And later on, the Registry of Deeds are requesting that you have to submit it to them for purposes of gawin siyang e-title, no? Sorry, I cannot discuss anymore paano magpagawa ng e-title. Sobrang konting oras natin. But bakit ito siya orange? Bakit hindi diretso blue? Kasi po ang judicial forms na hawak ng DNR at saka ng DAR respectively, puro mga orange pa galing sa Bangko Sentral. Sila man gumagawa nito. Sila nagtatype nito. At ang ginagawa lang po niyan, sila po yung nagbibigay ng patent, si DNR. Ang nag-award naman ng CLOA is Certificate of Land Ownership, and award is ang DAR. All Executive Department. And anong trabaho ng Registry of Deeds? Pinapasa lang na ito sa Registry of Deeds for purposes of registration and entry. Kasi ang Registry of Deeds po, siya po yung repository of all records, no, in the Philippines under the torrent system. So pagkatapos nilang register niyan, babalik din yan sa kanila doon para ipagpapadistribute na yun nila sa mga farmer beneficiaries. Tayo, ang trabaho ng ROD is i-register lang. Okay, that's why it's not a blue title. Alright? So later on po, pag malipat na yan, yung transfer certificate of title, magiging blue na yan because isasabit mo yun sa Registry of Deeds for purposes of transfer of titling. Alright? So another kind of title that you should know is itong condominium certificate of title, no? Ito yung sa condominium unit. And take note that sa condominium certificate of title, baka magtaka kayo, merong ownership ang may registered owner doon na foreigner. Yes, because ang foreigners are actually allowed to own condominium units, no, with the here in the Philippines, no. Ito po yung condominium certificate of title, issued po yan sa kanila. Titulo rin yan. And the last one is itong ang transfer certificate of title. When it is already transferred, no, from the OCT, TCT, lipat ng lipat, CT na siya, it's considered as transfer certificate of title. In most cases, ang transfer certificate of title carries the old annotations doon, no? Kung ano yung mga annotations sa previous nila, as derivative titles, magkakaroon sila ng carryover annotation. Take note that itong transfer certificate of titles are actually called derivative titles. Ano yung derivative title? Second title ba? In lieu of those one na na-cancel. So, klaro lang po tayo nito, no? So, with that, I think you know now at least yung mga basic on the kinds of title that you might encounter in your practice in the real estate profession, in our real estate profession. All right. So, ang pinaka-basic po natin gawin if a client wants to buy a property is to verify the title, no? It's what we call verification of title. Of course, we have to go to the Registry of Deeds. Now, if it is an orange color or even the blue one, pag hindi sigurado yung owner, sigurista, sabi niya, hindi ito, fake ito, fake. Baka fake ito. Delikado tayo. Now, I am not an expert on how to know whether it's title is fake or not. May basic ako na alam yung mga makita mo parang may balahibo sa loob, no? And it's made of security paper, parang blank check. Galing yan sa Bangko Sentral. However, the best agency talaga na makadetermine to satisfy your curiosity is of course the Registry of Deeds, no? When you verify a title. So, pwede man yan hangyuin niyo si request niyo yung sellers, mama, parang sorry wag kayo magalit. Ano lang. Kasi yung client ko parang hindi siya satisfied. Gusto niya ipa-verify kung itong title na ba ito is genuine ba ito. So, you could request. No? If the seller naman really wants to sell it, hindi siya dapat masasaktan, no? Dahil doon sa statement na yon. So, sige, punta tayo sa ROD, samahan kita, ipakita ko sa'yo, ganun. Okay? So, pwede po, no? And you have to present the original owner's copy of the land title kung necessary, no? Kung necessary, no? Hindi ko sinasabing always, no? Marami pong instances yung nasa orange title. Pag orange po, ako, pinapresent ko talaga yan siya. Kasi marami pong peke. Kasi manual typing lang yan eh. Hindi yan siya computerized, hindi pa siya e-title. In fact, marami na pong mga instances na pina-verify ko yung original orange title doon po sa Registry of Deeds. Pagkita nila fake, hold ka agad nila eh. Hindi na nila isa sa ulian sa'yo. They will just issue a certification na fake. So, now, at least, later on, the ROD will go after them. Okay? So, with that, na-present na po inyo ang title. Pero kung ano naman, yung e-title, minsan ako, hindi na ako na magpa-verify niya kasi mahirap na ito i-fake. May barcode yan eh. Look at meron siyang barcode. No? Ano pa ba ang makita natin yan? Grabe ang security papers. Meron pa siyang tawag dito para o yan, barcode dito. Ito pala QR code dito niya. Parang gano'n. Oh, and it's may serial number pa sa side, and actually it is already computer written, no? Even the signature is a stamp impression here by Registry of Deeds before si Maria Teresa Pescadera, no? Attorney Pescadera. So mahirap, no? I do not know kung talagang mapepeke pa ang blue. But if you really want to, why not? Di ba? By the way, meron pa pala dito sa taas, I would like to see ito. Judicial form number yan, Revised 2013. Okay. Alright, so I think all of you have seen this title. Otherwise, you are not here, no? Then after that, stop na ba tayo? Hindi, ang next nating step is to get a certified true copy. Electronic din. Secure a certified true copy of the title, the same title, no? Now, ang maganda po sa set system ngayon is that mabilis na po magkuha ng certified true copy. Noon, kasi ipapa-xerox lang, tapos may stamp. I think naabutan ni Sir Alex yung stamp na ganyan. Problema noon, pati yan, pwede yan siya i-fake eh. Meron nga akong case, napakulong ko ng mga about 8 years lang naman, falsification of public document. Fake ang certified true copy. Genuine ang title. So, ang certified true copy na is fake. Yung pala, meron na palang problematic annotations yan. Tapos, pinrenda niya. So, nagkaroon po ng kaso. And then, of course, tingnan natin sa last yung memorandum encumbrance kung meron siyang tinatawag natin yung mga malinis ba siya. That is now a clear indication that it is a clean title, di ba? Kasi wala sa memorandum encumbrance sa pinaka last page niya, wala kang makita na annotations, and even on the other second or third page, ito kunyari 2 pages lang ito, no? So it's a clean one. So okay tayo dito. Now, what if you did not do this verification of title? No? Suppose you did not. Kasi if you did not, it's possible hindi mo na-determine yung mga problematic annotations. Right? Bakit ko hindi i-verify? Tapos binili ko bigla. Diba? Makatulog ka pa kaya niyan? Hindi ka makatulog niyan. Bahunguting yan. Maglurat lang yung mata. Clean title ba yung binili ko? Clean title ba yung binili ko? Ito naman mag-asawa, diba? So, yan. So, ano ba yung mga problematic annotations na possible na kaya kailangan natin magkuha ng certified true copy is to determine this, no? This kind of possible annotations na hindi natin makita. Remember, there are 2 titles, no? One title is the owner's copy and the second is the ROD copy. It's possible that yung owner's copy malinis as it presented to you. However, dun sa ROD, merong mga involuntary annotations or dealings na pwedeng ipa-annotate doon without using the owner's copy. Kaya, it's possible na yung ROD copy madumi, yung owner's copy malinis. Okay. So, kaya, yan ang kailangan importance natin. Kaya, kailangan natin ng certified true copy. Okay. Ano ba yung mga problematic annotations na we will run it down fast and briefly, no? Number 1, ito, adverse claim. Pinaka-importante yung adverse claim. Napakadelikado nitong adverse claim. It means to say that another person is claiming an adverse either the whole or a portion of the property against the owner of the property. Ibig sabihin, meron siyang stake, may claim siya. Yan na lang, baka nabentahan ng one half portion or 1/4 portion, or baka meron talaga siyang omitted heir siya, hindi niya siya nasali sa mga pirmahan, dati siya co-owner, things like that, no? Makikita mo yan, adverse claim. How to do that is make an adverse claim, affidavit of adverse claim, have it annotated. The registry of deeds will look at it, kita niya, yes, registrable itong adverse claim mo, i-register yan. Yung owner's copy mo, malinis. But this one, dito ma-annotate sa ROD. So, at least, kung talagang i-verify mo, edi, uy, may adverse claim pa ito. Oops, sandali. Careful muna ako, may problema pala ito. Although, even then, pera-pera naman yan, pwede pa rin yan siya if you really want to. Edi, kung ano yung claim ng claimant, ibigay mo. Para ma-remove ang adverse claim. How to remove? It can be done by the adverse claimant through a petition to remove an adverse claim. Or, if not, pwede rin yung judicial, no? Pero magastos na yun. Kailangan mo ng abogado. Ano pang problematic annotations na possible, no? Number two is itong mortgage annotation. Baka nakaprenda. Okay lang ito kung nakaprenda. May real estate mortgage. Okay lang yan, sir, kasi bayaran namin yung naprendahan. Okay. Bilihin na namin kagad yan. Sabi ko, sige, matigas ang ulo mo. Bakit man, sir? What if kung sa mortgage, real estate mortgage annotation, meron doong right of first refusal na siya muna ang first bibili bago ibenta sa iba. Ikaw, pataka ka, bilihin mo kaagad. You have to get that, not only the mortgage annotation, but the real estate mortgage itself. You can ask it from the mortgagor and mortgagee, yung nag-mortgage, yung seller, and doon sa naprendahan. Or kung hindi, ingin ka ng traceback document from the registry of deeds. Basahin natin ba? Then, with that, pwede mong bilhin pero subject to the payment of that mortgage. Remember that even if it is a mortgage, hindi pwede ilagay sa real estate mortgage na prohibited ang nagprenda to sell it. No, that is void, no? The Supreme Court is clear about it and the law is clear about it. There can be no provision in the real estate mortgage na prohibited ibenta within the period of mortgage. Pwede po ibenta. As long as bayaran po yung nautangan. Okay? Take note of that. And lease pendants. Ano ito? It's a Latin term for pending litigation. Ibig sabihin, may pending na kaso. Delikado na yan, di ba? Bakit may kaso ito? Subject to kaso lupa. So it will subject to recovery possession, ejectment, action reinvestigatoria, action publicana. Alam mo yun, yung recovery of ownership, recovery of possession. Magulo. May proseso pa, pero just look at the other video lectures on how to do it. No? But these are the things na bantayan natin, no? And to do it, say, oops, hindi mo muna. Okay. And attachment or level execution. Ibig sabihin, natalo na siya sa kaso or na nag-order na ang judge na i-levy na ito, ibenta na sa public auction, di ba? Diba? Or baka foreclosed na siya kung mortgage, di ba? Binibenta na sa public auction. Ikaw, hindi mo alam, bili ka. Di, masaya masyado yung double income siya. Right? And, ito, basic. So, homeowners deed of restriction. Ito na pababayaan ito kasi ang intention mo, kung bili ka ng property sa isang village, kasi sabi mo, makita ako, giikot-ikot ko ng village na ito. Wala palang tindahan dito. Bilihin ko ito para magawa akong tindahan. When you find out that the deed of restriction says you cannot put up a tindahan there, kailangan residential lang. Okay. Or baka ang plano mo, gagawa ako ng duplex dito. Para, yung deed of restrictions pala, nakalagay doon, single detached lang ang pwede mo ilagay. Ngayon, magawa ka ng duplex. Kasi dalawa asawa mo. Doon siya sa isa. Joke. But what I'm trying to say is that ang deed of restrictions, bantayan natin, no? Para malaman mo kung magkano homeowners dues, ano ang mga regulations doon. So, before you enter into that community, kasi pag may homeowners kasi, ibig sabihin, there is a community within that particular subdivision. Usually, pag yung mga close yung North Crest, ano pa ba, dislawa, ganyan, no? So, meron silang restriction siya, no? Tsaka alamin mo kung magkano bayad, no? Etc. Alright, importante po yan, no? So, and, of course, yung lease contract. Well, ang lease contract is very important because the moment you buy it, you have to respect the lease, existing lease, no? Whether annotated or not, you have to respect that. Kaya lang, pag naka-lease po yan siya, by looking at the place, merong building may nag-lease, iba hindi iba ang naka-possession, then you have to talk to the seller. May lease contract ka ba? I would like to see. Bakit man? I would like to see how long ang inyong lease contract, kung pa-expire na ba o hindi. That would make you an intelligent decision whether to buy it or not. Kasi kung purpose naman is gusto mong kumita, kasi ikaw rin ang pagbili mo, ikaw na rin ang maniningil, di ba? Part naman yan siya sa stock and barrel yan. Pagbili mo sa lupa at building, ikaw na rin maniningil as a new owner. Or baka gusto mong gamitin, verify mo kung gaano katagal ang lease agreement. Ay, 1 year na lang pala. O sige, bilhin ko ito. Anyway, after 1 year, makalikob na ako ng pera, makagamitin ko na ito for on my business. I-stop ko na yung continuance ng lease. Okay? And second, you have to also look at the lease contract just like the mortgage annotation, real estate mortgage. Kasi baka may option to buy siya doon. Pag may option to buy, kailangan i-offer mo na sa lessee. Paano kung binili mo without looking at that na meron palang right of first refusal or option to buy? Diba? So, na-bypass mo yun, pwedeng i-cancel or pwedeng questionin ang deed of sale ninyo ng lessee. Kasi, lessee sometimes, they have interest on their property. Ang classic example po ng mga lease contracts na may option to buy, yung mga gasoline stations. Because they have this interest over the property. Na may business sila. Nakabaon na yung mga tangke sa ilalim para sa gasoline. Tapos, benta lang sa iba, di ba? So, they might want to buy it first before i-deal sa iba. Alright? So, take note of that. And, ito, very important, Rule 74 of the Rules of Court. Kapag may naka-annotation po ng Section 4, Rule 74, ibig sabihin po, that property came from mana, succession. Nanggaling yan sa succession. So, nagkaroon ng extrajudicial settlement at nalipat sa pangalan ng mga heirs. Be careful with this. Kasi meron yun siyang 2-year lien. Ano yung 2-year lien? 2-year lien, hindi naman prohibition, pero warning lang ba sa any buyer from the date of death, execution of the AGS, that any deprived creditor, yung hindi nabayaran na creditor, or any omitted heir, yung hindi sinali ng mga heir, they can question it within 2 years. So if you buy it, you are subject to that lien. That is a warning na pwedeng i-recover back sa'yo. Alright? So, and others, no? Marami pong iba pang mga situation. So, here is an example of an electronic certified true copy na may annotation. Not really that much problematic. I got this from www.bohol.realty, no? Ito po, first page, second page, and third page. Okay. Let us check on this, no? So, we will start with this first page, no? So, you'll notice, certified true copy, makikita mo yung title number, okay? And yung lot number, yung name of owners. But what I would like to emphasize here on the certified true copy, electronic siya. Hindi na to mga peke eh. Here, look may OR number siya, may OR date, may amount paid, may barcode, reference number, date and time it was issued, and kanino ang naghingi ng certified true copy. So imagine that, very very secure na po talaga. Tapos, ito tinatanong sa akin ng mga subscribers ko, Sir, ano na yung unofficial copy if not of blue color? Yes. Kailangan kasi blue. Kasi pag meron ka certified true copy na nakikita na color red or color green, ay hindi yan galing sa registry of deeds. It must be blue. Okay, yan ang ibig sabihin yan. And then, ang second page natin, we will try to look at this. Second page, ito. Nandito yung continuation ng technical description and ito ang kanyang area, 1,172 square meters. Ganun pa man din, nandito pa rin yung mga features, no? Security features ng reference number, date time, OR number, or date amount paid, at saka yung barcode. And makita mo dito, it's page 2 of 3. Ibig sabihin, there are 3 useful pages, no? Alright. And the third page, iyan na. Sa Memorandum of Encumbrance, mayroon palang annotation. So, liabilities under Section 4 Rule 74. Ito yung sinasabi ko. That it has a 2-year lien. And you have to determine kailan ginawa. So, if it is July 14, 2011, so 2 years from there. Kaya, pag meron ganyan, sabihin mo sa kliyente mo, ma'am, nasa period pa tayo ng 2 years. Careful lang po tayo. Anong ibig sabihin careful? Ibig sabihin po, mag-exercise tayo na yung super extra due diligence. Meaning, investigate talaga natin kung, number 1, nabayaran ba lahat ng utang? Okay. Second, alamin po natin lahat ng heirs, kung lahat ba sila nakapirma sa AGS. Tingnan natin yung AGS po. May kopya pa yan sila or hindi, ingi tayo ng traceback document. And if you'll be able to satisfy na talagang kompleto sila, especially if kilala lang rin nung buyer yung family, okay lang. Identify niya ilan lahat ng mga kapatid, no? So, you could buy that. Wala, medyo makatulog ka na mahimbing. Ang iba naman, sinasuggest ko sa clients ko is that kapag meron sila nakita ganito, tapos nag-expire na yung 2 years, before bilihin is mag-file muna ng petition to remove, no, this annotation on Rule 74, Section 4. Alright? Para at least pag-transact, malinis. Okay? Alright, so yan po ang classic example ng Rule 74. Ito naman, bigyan ko kayo ng kasi ng lease pendants, no? So, ito example ng lease pendants, no? Filed by Attorney Juan de la Cruz, no? Notice of lease pendants, entry number 14344, dated May 5, 2022. Yeah. Filed by Juan de la Cruz, counsel for the defendant. Kasi pwede kasi ang lawyer ang mag-file ng notice of lease pendants, either plaintiff or defendant. Tapos nakalagay dyan yung civil case number, anong branch na hulog, sino yung parties, and ano ang klaseng kaso for recovery of possession pala of real property. So, ibig sabihin, may kaso ang lupa, merong agawan. Now, if you really want to buy that, you have to secure the services of a legal professional here. Para po, pwede nyong ipa-verify sa court, ano bang kaso na yan? Kasi meron akong situation ganyan noon na pina-verify sa akin na the client of mine was bank, no? And my client wants to buy a property from that bank pala. Sabi niya, boy, mura masyadong benta sa akin kaya may pending case. Pwede mo i-check ito. Sige, check ko. Pare, kaibigan ko eh. So, check ko sa court. Only to find out na the issue with respect to the land is already finished kasi nanalo na pala yung bank. Ang issue na lang remaining on appeal is yung laban ng mga co-owners. Kasi co-owners ang nag-prenda tapos pinorclose ng bank. So, ibig sabihin, yung issue on foreclosure, sabi ng bank, yes, affirm, tama yon. Ang inappeal lang nung kabila is that yung agawan nila paano mag-reimbursement ng damages and expenses. Sabi ko, so ibig sabihin, wala na palang lease pendants, wala na palang kaso with respect to the land. So, hindi pa man nasabit sa Court of Appeals ang papers. I filed a entry of appearance with motion to remove the lease pendants. Order the Registry of the Deeds to cancel the lease pendants. On a hearing judge, sabi niya, nga, no, hindi na nga pala. So, sige, order. Acting on the written motion filed by Attorney Raymond Batu, counsel for the plaintiff, the motion is hereby granted and the Registry of Deeds is directed to cancel the annotation of lease pendants under entry number 14344 dated May 5, 2022. Then, that motion granted na, bilang ako 15 days. Pagka 15 days, hingi ako ng certificate of finality, bigay ko yun sa Registry of Deeds, magkakaroon ng entry na naman dito sa baba niyan. Ang nakalagay sa baba niyan, entry number, let's say, 17695, decision of the Regional Trial Court directing the removal of these list pendants. Di ba? Which has attained finality, signed and everything. So, malinis na po ang property. Okay, so yun po ang technique. But remember, kung meron po kasing mga annotations, yung mga problematic annotations na discuss ko, including Rule 74 at saka list pendants, it is actually a binding notice to the whole world, no? So, pag it's a binding notice to the whole world, ang meaning po niyan is that you buy it at your own risk. Alam mong merong kaso, binili mo pa rin. Or, hindi ka nag-conduct ng due diligence, hindi mo pwede sabihin na, hindi ko kasi alam. Hindi. Kasi by the fact na may annotation doon sa ROD copy, it is a notice to the whole world. Hindi ka pwede magsabi na, hindi ko kasi alam. Kung alam ko lang, sir, hindi. That is not a valid excuse. Because automatic po yan, notice yan siya. Parang notified ka na automatic kahit na hindi mo nakita. Yan ang ibig sabihin. Notified ka automatic kahit hindi mo pa nakita. Basta may annotation po. Yan po yung notice to the whole world. Okay? So, having said that, we will now go to the next thing that you should do. Okay, let's say, we'll assume na malinis ang papel and everything. Now, sino yung nagbebenta? Alamin natin ngayon, sino itong seller? Bakit kailangan natin malaman? Magmarites pa tayo, malaman natin? Hindi naman po. Kailangan po talaga yan. Why? The first thing that you should know is if the seller is married. Okay. Bakit po kung married? Kailangan ng marital consent, di ba? Alright. Is the property co-owned? Meron bang co-ownership, no? Meron ba, is the seller married to a foreigner? Yun ang mga basic, no? Is the seller a corporation? Okay? Or are we dealing with an attorney in fact? Yan ang pinaka-importante, no? Baka kasi we are dealing with an attorney in fact. Iba rin yan kasi attorney in fact steps into the shoes of the principal at meron na siyang authority to do a certain thing. Now, I would like to clarify that pagdating po sa SPA, ako po very, very strict on that because dyan po nagkakaroon ng mga problem. And the Supreme Court said, when you're dealing with a middleman, para middleman ang attorney in fact, di ba? Hindi naman siyang may-ari. He's just acting in behalf of the principal. Sabi ng Supreme Court, exercise the utmost prudence to determine these things. No? Kaya sabi ko kapon sa inyo, you have to investigate. You can video conference the principal, bakit hindi kayo makapunta dito? Bakit nandyan kayo? Nandiyan ka lang pala sa Davao, bakit hindi nagawa ka pa ng SPA? What's wrong? Things like that, no? And bakit hindi ka makapunta? Ay, kasi bedridden na pala ako. Bedridden ka? Teka, pwedeng makita sa video, yun pala. Ay, kasi na-stroke siya. Pero makasalita ka pa, maintindihan mo pa ito na talagang nagbigay, yes, meron ako niyan. Notarized, duly notarized. Okay. So, para mga things like that, no? So, mayroon pang isa dito, na kailangan nyo pong gawin, no? Later on, I will discuss to you, ipa-analyze ko sa inyo anong kulang sa ating due diligence. Okay. Now, know the seller, no? What if the seller is married? Okay, doon tayo sa first, no? So, if the seller is married, ang dapat po nating alamin is, number one, meron bang tawag na prenuptial agreement? Ano yung prenuptial? Yung gumawa sila ng kasulatan na ang kanilang property regime will be governed by another kind of property regime. Wherein, sabi nila, separation of property kami. Yan, ang aming complete. Kasi may isa, sabi niya, sir, we are, although married po nakalagay sa title, but we're actually complete separation of property. Ganun ba? Okay, tingnan natin kung meron kayong prenuptial. At was it annotated and was it duly registered, no, before the marriage? So, alamin din natin po, no, kung sakaling when is the date of marriage, no? Bakit importante ang date of marriage, no? Kasi ang sabi ng batas, no, Family Code, kapag kinasal ka August 3, 1988 pataas, you are governed with the rule on absolute community of property. Ibig sabihin, pag anong property mo, pag-asawa mo, existing at the time you're single, magiging co-owned na yan ng asawa mo ngayon. Ganon din sa kanya. So, what you own, I own. What I own, you own. Ganyan. Pero kung married ka August 2, 1988 downwards, iba ang rule, conjugal partnership of gains. I cannot discuss the details of it, pero meron kasing, pwede kasing i-retain as exclusive ownership, no? Pwede kasi doon sa conjugal partnership of gains, no? So, ang reckoning date po natin at tandaan natin nito is yung August 3, 1988. Why? Because yan po August 3, 1988, dun po nag-take effect si Family Code. Okay. From that moment on, pag magkasal ka, tapos wala kang prenuptial, automatic po absolute community of property. Now, there is a bill, pero parang nambatay hindi na yan natuloy, trying to amend the family code, which says that kung pagkasal, automatic separation of property sila. And saka na lang sila mag-prenup kung gusto nilang absolute community or conjugal partnership of gains ang kanilang gusto. Sa akin naman, mas gusto ko yung ganon para walang issues na mga about their properties, no? Because later on naman, kung ano naman yung pwede na pag-usapan na i-co-own nila, okay, no? So maganda kasi yung may respect sa kanya-kanyang property, no? Yan kasi nagkakaroon minsan, no? Let's say, the boy, the man, received a mana from the parents or donation when he was single. Nung pagkasal niya, automatic co-own na yung wife? Ayaw na ayaw ng parents yung wife. Kung ayaw ko yun, tingnan mo, ang property na dinonate ko sa kanya, anak ko, co-own tuloy sila. Kahit tapos single ang nakalagay sa title. And ibang registry of deeds humihingi ng senomar Single ka, parang hindi ka single. Hingi ako ng senomar to prove na you're really single. Pag nakitang married, sabihin mo, ay hindi ma'am, galing man ito sa pagkabinata ko, na-acquire ko ito. Pagkabinata ko, either sale or gidonate sa akin. Nevertheless, kailan kayo kinasal? August 3, 1988 onwards? Yes, sir. Then, automatic absolute community of property. What you own is also owned by your wife. Ganun sabi. Kaya kahit nasabihin natin single in the title but married at the time of sale, ayan, kailangan pa rin yan siyang marital consent na. That is the consequence of this absolute community of property. It becomes co-ownership at kailangan natin ng marital consent. Now, ano po yung sitwasyon na married po but divorced naman abroad, no? Well, actually, we do not recognize divorce, but there is a pending bill, pero parang natutulog pa man. Wala pa tayong law on divorce, no? So, kung may divorce abroad, the thing that you should do is that, may divorce na kami, is that get the divorce papers and file a petition here in court for a judicial recognition of divorce. Tingnan natin kung i-recognize ba. May stricto ang Supreme Court, ang korte, when it comes to recognizing a foreign divorce. They only do that if ang mag-asawa is yung foreigner at Pilipina, tapos yung foreigner nag-divorce abroad, tapos that foreigner now becomes available again to marry, parang naging single siya ulit. Unfair naman dito sa babae na ma-maintain siya as married here in the Philippines. So when we file a petition for recognition of divorce, the court will grant it on the ground of equity. Kung yung foreigner is laya na siya sa kanyang kulungan asawa, dapat palayain natin din ang asawa dito sa Pilipinas. Yun ang nakikita kong usually ina-approve ng recognition of foreign divorce kapag foreigner ng iba ang nasa taas. Especially if kapag yung mga naturalized citizens na doon, even if Filipino before. Okay. Ina-approve yun siya. Ganun din ang rule kapag married nga pero separated in fact. Dugay na kay may bulaga na, sir, 30 anyos na, 40 anyos na. Subot pa sabot, wa na jud say labot ana. Sorry ma'am, kay nakabutang sa title po, married to. Kailangan pa rin natin ng marital consent, no? So, huwag kayo maniwala niyang 30 years. May batas po tayo, sabi niya, na 30 years na hiwalay, automatic, wala na yan. No, there's no such thing. In fact, mag-file ka ng petition to declare your husband as presumptively dead or wife presumptively dead, kaya hindi mo na nagpakita sa'yo for how many years? Ba? That is only for purposes of remarriage, not for the purpose of allowing you to sell it without the marital consent. Di pa rin pwede. Now, suppose sabihin nila, well, annulled kami, sir. Okay, let me see the decree of annulment or nullity or the decree of legal separation. Now, the rule is that kapag may decree, ito nga ang kwento ko always nag-grant na yung annulment, nullity, or legal separation. Happy na si wife or si husband na nag-grant. Question is that is that automatic? No. You have to wait for 15 days. And it becomes final, you get a certificate of finality. May finality na ako, attorney. Is that enough? No. You have to have that annotated doon sa marriage contract ninyo. Plus, yung i-annotate po rin sa registry of deeds where meron kayong mga properties. Kasi in action for nullity and annulment of marriage and even legal separation, hindi lang po pinag-uusapan ng hiwalayan. Ang pinag-uusapan din po, no, is yung property relations. Kasi kung marami silang properties, o sige, Mr. sa husband ito, lupa na ito, sa wife itong sa Ladislawa, sa husband ito sa North Crest, nakalagay yan doon So, dapat, kapag final na siya at may decree na kayong decree of annulment and nullity is final already, you must have it annotated doon sa registry of deeds para hindi na kailangan si marital consent. Okay. And, dagdag kaalaman, kailangan po is ipa-annotate nyo rin po yung decree doon sa marriage, sa local civil registrar. Why? Because if you marry without annotating it, that second marriage is considered as void. Void, So, requirement po yung annotation. Huwag po excited. Baka wala ang annotation, minyo dahil ayaw. You have to complete the process. Okay? So, another thing is that meron bang, sa seller pa rin tayo, meron bang co-owners, no? Remember that there are two kinds of co-ownership, no? Meron tayong voluntary co-ownership, yung a group of friends would like to co-own something and buy property and they will co-own it. Even they become co-owners in a sense that each of them must give their consent kung sakaling ibenta. Or mga live-in partners, pwede sila magbili, no, for purpose of co-ownership. Meron dito tayong forced co-ownership, yung mga heirs, no. Wala silang choice na they become forced co-owner pag namatay yung mga parents nila or mga ninuno nila, di ba? They become co-owners from the time of death, no? Yan ang sasabi by operation of law. Kaya pag sabi, time of death, 10:35, January 23, in that particular instance, automatic is that you are considered as an owner of that property already from the time of death. By operation of law, hindi na kailangan pang decision ng korte or pronouncement. By operation of law, yan ang sasabi. Okay, so, kung ang kliyente mo in this situation is buying only a portion or the whole lot, you have to know it. Kasi kung portion lang, number one, tingnan mo yung baka rolats yan. Yan ba yung discussion ko kapon? Careful, ma'am, magbili ko portion. Ang first question ko kagad, gaano kalaki? Mga 200 square meters. Gaano kalaki ang mother title? Sir, mga 5 hectares. Alam ko na rolats na yan. So, nagitagi-tagi na ni? Subdivide, yes sir. Then I will tell them na, do not buy these things. Pero meron din talagang legit na portion. Let's say, the portion talagang bibilihin. So, ang gagawin po natin yan is that kailangan po ng partition agreement muna ng heirs. No? Aside from the fact yung settlement of estate, may partition agreement. Magpa-subdivide sila sa geodetic engineer. Let's say, lot 1, lot 2, lot 3, lot 4. Ang bibenta si lot 1. So, ang question is that, kailangan bang mag-sign ang lahat? Yes, sir. Because wala pang determination kung kanino na-assign yung partition na yun, yung 1, 2, 3, 4. Kaya nga, kailangan ng partition agreement. Pag may partition agreement na, let's say, sabihin kay A, sa'yo yung 1, kay B, sa'yo yung 2, yung C, sa'yo yung 3, yung D, sa'yo yung number 4. So, once may partition agreement duly notarized, so si A, na siya ang nakahawak sa 1, pwede na niya ibenta sa'yo. Kasi from that moment on na may partition agreement na segregate na, there is no more co-ownership to speak about, but individual ownership. Pero sabi mo, attorney, ibuo pa man ng title. Yeah, no problem. Pwede naman yan siya ipa-split. And in fact, meron na tayong individual technical descriptions ng 4. Meron ng kanyang description. Yung technical description ng 1, yun ang gagamitin mo sa deed of sale. Gawa rin kayo ng petition for splitting of title and isubmit nyo sa ROD para ma-split yun 4. Yan. And later on, by deed of sale kayo, sabay nyo na yan. Paglabas sa title, 4 ang lalabas, 3 doon sa heirs na hindi nagbenta, 1 is to you kung ikaw ang nagbili. Kasi, naggawa mo na yung process na yun. Okay? So, take note of that, ha? So, but if it is a whole lot, wala naman problema. Diretso na, no? Lahat lang silang mga heirs magpirma. And you have to take note that they have to settle the extrajudicial settlement, no? Now, ang amnesty natin is June 14, 2023. Kung namatay from December 31, 2017 pababa. Kung namatay January 1, 2018 pataas, covered na tayo sa train law. Kasi yun ang date of effectivity ng train law, January 1, 2018. Now, ang amnesty natin is up to June 14, 2023. However, I made a video lecture that there is a possible extension again of another 2 years. I hope you would watch that video lecture. Find that in the YouTube channel, no? Because there's a bill being passed. So, in that video lecture, didiscuss ko ang procedure kung paano gumawa ng batas. Yung from the House of Representatives, yung first reading, second reading, third reading, pasa na naman sa Senate, first reading, second reading, third reading, tapos pasa na naman sa bicameral committee, then ibabalik na naman sa House and Senate, padala sa President. Now, is that period enough to cover na ang petsa natin ngayon April 23? And it's at least more than 1.5 months na lang or less than that, no? Baka hindi na tayo makahabol, no? So, ang sabi ko is that you have to apply for it na. So, in this particular case, kung bibiliin ang whole lot, extrajudicial settlement with a state plus partition, or kung hindi partition, the whole lot, everybody must sign. But take note that when you buy it at risk na merong annotation ng Rule 74 lalabas sa title na nabili ninyo. Kaya sabi ko, super extra due diligent tayo nito. Okay. So take note of that. Sino magbayad ng extrajudicial settlement? Of course, ang heirs. Hindi po kayo. Sino magbayad ng real property tax? Of course, sila. Sila pa rin. Sino magbayad ng capital gain tax? Kung walang usapan, sila dapat. Kasi silang may gain. Pero usually, ang uso ngayon, net. Net kami, sir. Okay. Pero sa net, pagdating sa AGS, extrajudicial settlement of estate tax, and sa real property tax, sila pa rin. Ang net means sa capital gain tax lang. Okay? Take note of that, ha? So, now, if you buy it from the heirs, kailangan po natin malaman ito mga bagay na ito, ha? Who are the heirs? Ano ang names ng spouses and address? Kailangan kasi natin ilagay kahit na hindi po magpipirma ang spouses sa extrajudicial settlement because these are actually inherited properties, actually exclusive property yan. Wala pong kasali, walang paki ang asawa niyan. So, tingnan niyo yung video lecture ko. Anong pakialam ng asawa ko sa aking exclusive property? Yung mga mana, donation, gratuitous transfer, o ilabot ang asawa. But, you need to put that in the document na married ka niyan. It is just a description that that particular owner heir is married doon sa asawa na yan, sa spouse na yan. Okay? Otherwise, hindi yan tanggapin ng Registry of Deeds. Ilan ang heirs? Alamin mo talaga kung ilan sila, no? You have to investigate. One technique na ginagawa ko is hinihingi ko yung yung birth certificate. Bigay niya sa akin, sir, 4 lang kami talaga. O sige, tingnan ko. Makikita mo sa birth certificate pang ilan siyang time, pang ilang birth na siya. Pang 5 ka naman pala na anak. Ibig sabihin, 6 kayo. 5 kayo. Hindi kayo 4. Diba? So, where is the other one? Ayan, technique, no? Patay na, sir. Tagay ko certificate of death. Sir? May anak yan? Bakit, sir? Right of representation. Ano right of representation, sir? Yung mga anak niya mag-represent sa kanya. Yan, no? So, meron pa rin tayong video lecture on right of representation. Kindly view it in. Alam mo, doon sa channel natin, nandun halos lahat, no? Mga problematic situations, no? And, yun nga, where the heirs, are all the heirs alive? Yan yung right of representation. Are there illegitimate heirs? Kasi, alamin natin kung illegitimate heir, kasi baka mag-demand ng pantay sa legitimate. Hindi naman pwede ka mag-demand ng pantay. Illegitimate ka 50%. Now, sa recent case decision ng Supreme Court penned by Justice Marvick Lunen, hindi na ginamit ng Supreme Court ang word na illegitimate child or illegitimate children. Non-marital child na po ang tawag sa kanila. Non-marital child or non-marital children. Okay. And meron bang minor heirs? Take note, pag may minor heirs po, hindi po pwedeng bilihin without court order. Kasi a minor cannot enter into a contract. They are incapacitated to enter into a contract. Okay? So, take note of that, no? Minor heirs. At alamin din, baka mayroon pang existing creditors, no? At the time of death. Very important po yung malaman natin kasi bayaran natin kung may napag-utangan. Okay. So, after that, malaman na natin kung may co-ownership ba wala. Ano ba ang next step gawin natin? Yung patuloy natin kung baka yung seller is married to a foreigner. Bakit ba kailangan yan, sir? Baka kasi binibili mo condo unit. Kung condo unit kasi, kailangan ng signature by both of them because a foreigner can own a condo unit. Pero kung lupa at bahay, hindi na kailangan si foreigner. Kahit na nakalagay doon sa title, married siya kay Tom Cruise. It is a only description that he is married to that American national. It doesn't imply na si Tom Cruise, yung American national, meron siyang ownership rights over the property because that is prohibited under the Constitution. Except by hereditary succession, lands in the Philippines shall be owned only by the citizens of the Philippines. Pero may except daw by hereditary succession. Kapag naunang namatay si Filipina wife, for example, in this picture, and that is the instance wherein si foreigner, pwede siya mag-own as compulsory heir under legal or intestate succession, yung walang will ba? Bawal man bigyan ng will. Alright? So, that is an instance. Pero one share lang siya. Kung meron silang anak, share sila ng anak. Kung walang anak, tingin tayo sa taas, baka may parents, mag-share siya dun sa parents na babae na namatay. Kung walang tatay, wala lang anak, mag-share siya kasama ang mga kapatid. Okay. Meron akong bagong lang ginawa na extrajudicial settlement na ganyan. Wala silang anak, pero may mga kapatid yung babae na namatay. So, we have to make an extrajudicial settlement on that. Okay? So, take note of that. And, what if the seller is a corporation? Gusto ko i-emphasize na kapag ang nagbenta po a corporation is that ang corporation po, tao po yan. It is an artificial being created by law. Ibig sabihin, naggawa ka ng korporasyon, may pangalan siya, pwede siya mag-own ng property, pwede siya magdemanda, pwede siya idemanda. Pero ang nagpapatakbo sa kanya, yung board of directors. But kung gusto mo i-demanda ang korporasyon, hindi kasama ang board of directors. Kung hindi makabayad ang corporation, hindi mo pwede singilin doon sa mga board of directors. Yes, general rule, no? Kasi, may personality ang corporation. So, ang batayan po natin dito sa corporation po, ito po ang tandaan ninyo ha. You put this down. Number 1 is that hindi po ako satisfied sa secretary certificate lang. Kasi ang pipirma lang, secretary lang yan eh. Tapos, attested by the President. I will need, number 1, the articles of incorporation at saka certificate of registration. Number 2, hihingi ako ng general information sheet updated. Number 3, hihingi ako ng copy ng board resolution authorizing that person, or usually the President, to act for the corporation in selling the property. And 4th, yung secretary certificate. Bakit po? Kasi, number 1 is that, alamin natin baka ang corporation is already a dissolved corporation by non-user. Automatic mag-dissolve yan pag hindi na nagsasabit na mag-GIS. Now, ang corporation kasi na-dissolve, they have only 2 years within which to settle or liquidate the affairs of the corporation. Pag lumampas na yan ng 2 years, delikado. Without appointing a trustee within that period of 2 years, hindi ka makabenta niyan. Kasi yun, you need to have the court intervention na. Second, alamin ko from the corporation, kung hihingi na naman ako ng mga certified true copy ng mga titles na owned by the corporation. And if I cannot get that, hihingi ako sa city as a source ng tax declaration under the name of this corporation. Para tingnan natin kung maglabas ba talaga na marami siyang properties. Kasi kung yan lang ang property, ang both po of substantially all of the properties should be at least 2/3. Hindi po majority. Kasi baka yung board resolution na hawak-hawak nyo, votation lang ng majority. It should be 2/3 vote. Because it is sale of a substantially all of the property. Mas mataas ang requirement na approval. So, yun lang mga things ganyan. Kasi, I don't want later on, like, my client buys a property and later on, one stockholder will question na ang sale transaction dahil invalid, dahil kulang ng both requirements, etc., etc. Alright? So, careful po tayo dyan sa korporasyon. And including yung attorney. In fact, stricto po talaga ako dito. If the is from the abroad, consularized SPA, or yung apostille ang ginagawa ko. Find that also in the ating lecture room sa channel natin. Yung yung apostille na yan. Now, take note that sa apostille po, it is an important thing that the member country recognizes, is also a member of the Geneva Convention on Apostille, no? Kasi tayo Pilipinas, lately lang man tayo nagka-member yata, parang 2013, 28, somewhere there, 2013 to 2018. So, kailangan ang member state is member ng Apostille Convention and at the same time, tayo. Para, that's the only way na ma-recognize si apostille. Ano ba yung apostille na yan? Basic lang is that, gawa ka na SPA doon sa abroad. Yung ginagawa ko, gina-email ko yung SPA. Ako nagagawa talaga kasi meron akong form eh. Sabihin ko doon na, okay, you have it notarized by a, let's say in America yan, an American notary public there. Okay, notarized na. Yung notary na yan na SPA, dadalhin yan sa Secretary of State. Yung parang DFA nila doon ba? Ang tawag niya kaya Secretary of State eh. Certain state of Florida, ito state of Alabama, ito eh. At ipa-apostil yun. Pagkatapos apostil nun, hindi na kailangan dumaan ng embassy, padala na dito sa atin sa Pilipinas, FedEx. And that is now acceptable as a public document. Pwede na i-transact yan. Sabi niya, sir, malayo kasi yung Secretary of State. Sabi ko ba, karamihan is mas marami ang malapit ang Secretary of State kaysa ang consular office natin or embassy. Hindi sir, sa harapan lang namin ang embassy. Sige, baliktad, no? Okay. E di magpunta ka lang sa embassy and avail of their consular notarization. May bayad po yun. Nagno-notarize po ang consul, ang ambassador. And they have this consular section. And ang tawag po sa document is consular notarization, SPA. Bayad kayo. Hindi mo na kailangan magpa-notarize doon sa American lawyer. Diretso na kayo kasi sila na mag-notarize. Now, the rule is that para kasing yung embassy natin or consul natin, that is Philippine territory. So, kung nag-fix ka ng signature doon, by the way, wag mo muna pirmahan ha, doon mo pirmahan sa embassy talaga or sa consul, at inauthorize doon, parang nag-notarize ka sa Pilipinas. Kaya acceptable yan dito sa atin. So, you have notarized a document within Philippine territory. At papadala yan dito, FedEx. But, na-comply mo nga yan, masayang lang yung oras, marami ako nakita apostil at mga SPA sa consul, hindi naman tarong ang paggagawa ng deed of sale. Dapat ang SPA. Dapat kasi ang SPA, nakastate talaga yung sinasabi yung ano yung title ng property, number, gaano kalaki, sino ang registered owner, pagkatapos, ano yung technical description. Tapos, yung attorney in fact dapat may authority na magtanggap ng pera. Or kung hindi siya ma-authorize magtanggap ng pera, authorized niya tanggapin ang cheque under the name of the principal seller para i-deposit sa bank. Kailangan specific eh. Kaya special eh, hindi general eh. Karamihan yung iba, to sell all my properties in the Philippines, is that effective, no? That is a general thing. Kailangan specific po talaga. Now, the thing is that if you are given a special power of attorney to sell, it does not include the power to mortgage. If you are given a special power of attorney to mortgage, it doesn't include the power to sell. Kaya specific talaga yan. Kaya SPA, Special Power of Attorney. Take note that ang SPA po, may expiry yan kapag, number one, nalagay doon ang expiration date. Second, kapag nirevoke yan, the end na rin yan. And kapag yung sinabi ko sa inyo, ang principal is that yung mental faculties niya nagsuffer na. So, you stepping into the shoes as the into the shoes of the principal, mag-stop na rin yung agency ninyo. Ang tawag kasi niyan sa civil code natin, it is a contract of agency. And it must be specific, no? So, take note of that. But, aside from that, ang due diligence na ginagawa ko is that I also talk to the principal, as I said, no? And, another thing is that, kapag nasa Pilipinas po ang SPA lang ginawa, Manila, tapos Davao ang property yan, ma-understand ko yan. Pero pag Davao, tapos Davao din ang kanya. Sabi ko, teka, bakit i-authorize ka ng husband mo? Saan ang husband mo? Eh, malayo kasi sir, kaya kami, galit kami, kaya ayan, dedikado niya baka kasi pinorge lang niyo yung SPA ba? You need to talk to the principal. Pag hindi niya ma-available for talk, wag mo ituloy yung property, pagbili ng property. You need to talk to the principal. You need to video call. You need to understand bakit hindi siya pwedeng gumawa ng isang bagay na napaka-importante. Ay sir, wala ibang tindahan sir. O sige, wala ba? Atuhon ta ka diha, kung Davao lang man. Suguo na akong staff na ako, ako mismo mo ato din na. Papirmahon ta ka sa akong logbook, sa akong libro. Kita magbuhat ng SPA, diretso deed of sale, naramanday ka dali. Ay, anon ba? I'm so strict with special power of attorneys. Kasi yan po is very crucial. Ang dami pong pwedeng i-pick. Titingnan ko rin ang notary public na nag-notarize dyan. Kasi kilala ko kung Davao City lang, sino yung mga questionable na notary public. Marami pong mga fake stamps po, no? Huwag po kayo maniwala. Magpunta kayo dyan sa Sanggunian. Marami po dyan sa Sanggunian. Ito, direct na yung usapan ito. Maraming mga lawyers yan nag-notarize. Legit yan sila. Nandyan yan sila. Pero, ang hindi nila alam, yung stamps nila, pinipake yan ng mga barker. Yeah, let's say, notaryo dito. 100, 200. Sige, si attorney so and so, mo na siya ang notarize. Sige, ambil papel ni mo. Bakulat lang din na. Yan ang kuyaw. Hindi ka papirmahin sa libro. Kasi, what if kung hindi nila binigay doon sa certain attorney? Dahil meron pala silang stamp nila na pinagawa din. Kinopya nila. Stamp, tas kopya ng pirma, silyuhan, bigay sa'yo. Unsa na, sir, 2,000 na SPA. 3,000 na, sir, SPA. Bayad mo ka. Hindi mo alam, yung pala, hindi pala dumaan sa libro ng particular lawyer. Marami pong ganyan. The thing is that when you have something notarized, that is, especially pag yung transmission of rights, yung mga lease, mga contracts and everything, waiver and everything, you have to see the lawyer. And you have to, the lawyer must see you and sign on the logbook. Meron kami notarial logbook Blue ang color nun. Now, pag SPA, makita ko, oops, sandali, itong stamp ng panyero ko, parati ito kinukupya. Natawag ako niyan sa kanya. Kasi may mga numbers man kami. Bre, pakicheck daw itong doc number 1, book page 1, series of book number 2, ganun. Ano man, magawin notary room, duda ko ani ba? Mo ba? O sige, tanaw na. Wala ba? Wala ko ana. I have none. Mo ba? Ito ang pangalan, ito deed of sale daw ganun. SPA daw ganun. Hindi ako nag-notarize yan. O, di ba? Then you were able to conduct. Kaya sabi ng Supreme Court, when dealing with SPA, parang may middleman, be very, very, very careful on that. Karami pong falsified SPAs po. Ang Korte po, Supreme Court decisions, napakarami on issues on falsified SPAs. Especially, yung may mga processors na process mo title, bigyan mo pera, bigyan mo documents, pati ang original title, ibigay mo na kagad dun sa processor. Tapos, sa kanya na lahat. Pati dito si pirma mo. What will stop that particular assessor to make an SPA authorizing her to mortgage the property, allegedly, or to sell the property? Gawa niya. Tapos may picture naman siya doon sa'yo. Lagay niya doon ang ID, valid ID. Tapos, authorize siya. Tapos, iprenda niya or ibenta niya. In most cases, karamihan, hindi nila ginagawa yung benta. Kasi, SPA to sell. Pero ilagay na yan sa SPA nila. Ngayon, dalhin nila yan sa SP. Barker sila magdaan, kaya alam nila kaya i-forge, kaya i-peke. Ulat lang rin, ma'am. Balik lang. Pila man 5,000. Fake pala yun. Hindi talaga dumaan sa totoong abogado na nandoon. Kasi mga abogado na nandoon po, marami sila nag-notarize dyan, a little bit cheaper, pero they require personal appearance. Kapag barker, pag hindi ka pa isama, di lang ka sir, kaya di sila pasulod dito at questionable na yan. So, nandun na. SPA to sir. Usually, tingnan niya ang property. Kung vacant lot, yan, pwede yan ibenta kay turo niya. Ito sir, yung morning property. Baligyan. Ayahay kayo ang hente. Tingala. Diba? Iba na nakatitulo. Or, the second one is that kung hindi makaya kay may building, may naka-occupy pa, mortgage. Maraming mga loan sharks na maghahaman din na naga 10%. Basta lang mudawat, basta lang maunsa. Bawasan ko ito ng agent's commission at saka advance na interest for 3 months. Kanang utangin mo? 1 million. Bawasan ko ito ng interest na advance. Okay po. Ulang na siya kayo. Wala nga naman. Peke ko ng SPA. Importante makakuha siya ng pera. Tapos mawawala na yan. Pati ang mga original documents mo, mawawala. So anyway, I will be discussing this afternoon itong processing of title. No? Titling tayo. Turuan mo kayo paano maging careful on that and how to deal with the right people. And mas better kayong gumawa. Tell you frankly, ako, ginawa ko talaga yung mag-title. Yung, ako mismo, when I was younger. Okay? I'll discuss that here. So, yan po ang bantayan natin, ha. Now, We will go now to the documents. No? The documents na dapat nating ingatan at pag-aralan mabuti, aside from those things that I discussed. No? What are those documents? No? Itong deed of sale. Sa deed of sale po, kailangan talaga may complete technical description nakalagay dyan. No? Yung legit na notary public, sinasabi ko sa inyo, hanapin nyo na sa video lecture natin. No? Paano mag-determine ng legitimate notary public. Tapos, ang deed of sale, kahit hindi notarized po, valid yan. Klaro valid yan. Kahit na acknowledgement receipt nga, that's considered as a contract of sale. Pero, question is it registrable? Hindi siya registrable. Kailangan in-notarize siya. So, kung may kausapan na kayo sa papel, tapos dito ron sabi mo, pre, yung kasunduan natin sa pagbenta ng property, yung pagbili ko, yes, pwede ba tayo gumawa ng formal deed of sale para notarize na para ma-transfer ko na? Pag ayaw siya pumayag, pwede kang issue in court for specific performance requiring him to execute a registrable deed of sale. Okay? Deed of donation. Yung gratis transfer by reason of love and affection. Usually, galing yan sa parents sa mga anak. Now, remember, in deed of donation, the same na lang ang tax niyan. 6% and 1.5%. The same lang with the deed of sale. Gratis Tanggap yan ng free from the parents or even from the strangers. Ano ang requirement ng donation? Number 1, it must be in writing. It must be duly notarized. It must be accepted by the donee. Dapat yung pagbigyan is tatanggapin niya. Without these 3, invalid po. Void. Walang visa. Yun ang kaibahan ng deed of sale at deed of donation. Ang deed of sale, pwede piece of paper lang Deed of donation, no? Writing, public document, and it must be accepted. Dapat notarized. Okay? So, alamin po niyo mabuti. Kaya nga, lapit kayo sa peke na abogado. Is that a valid deed of donation? Hindi po invalid. Or magpunta kayo sa abogado na hindi naman niya pinapirma sa logbook. Walang valid identification. Hindi klaro, hindi niya gisubmit. Wala talaga. Ano yan? Ang sabi ng Supreme Court? Okay, hindi natin pag-usapan ang kasalanan ng abogado kay pwede man siya i-punish ng Supreme Court. But ano ang mangyari sa document? It is a defective instrument, sabi ng Supreme Court. It will not be considered as a public document. Now, kung sale, okay lang. Kay sale pa rin yun, but between the private parties. Pero kung donation yung ginawa, defective siya, hindi siya public instrument. It becomes a private instrument. Void. Kasi kailangan public document siya. Meaning notarized legitimately. Careful po tayo dito talaga. What I'm trying to say is just deal with the right lawyer. Wag kayo dahil nakamura kayo, happy kayo masyado, kamura. Meron mga mura na mga lawyers, honestly. But you have to go in front of that lawyer and tell them na, sir, wala pa kami nakapirma sa libro. Sir, wala pa kami na ganito. Valid ID namin, sir. Dapat kayo na mag-inform. Sir, we need a copy of this, And kung pwede ka, i-document yung transaction in front of the lawyer. Video kayo. Payag man kami yan. Picturean yung anong ginagawa. Payag man kami yan. Basta wag lang i-post sa Facebook. For private use lang. Kasi kung i-post sa Facebook, baka mag-violate kami sa client-attorney privilege communication. Pero, kung for purposes of evidence lang, private lang hawak ninyo, okay lang po yan. Okay? And extrajudicial settlement of estate. No? Sabi ko sa inyo, extrajudicial settlement of estate galing yan sa patay. And the estate tax amnesty is about to expire kung noon namatay. Kung namatay 2018, hindi nyo pa nasa-settle, may penalties na under the train law. Mamaya discuss ko sa inyo ano ang estate tax. No? Basta take note, pag extrajudicial settlement, it is settlement of the estate of the deceased. Patay na yung tao, yung ninuno nila, sila ngayon as heir. They want to formalize thing and acquire it, no? Adjudicate it among themselves that may lipat ang title under their name. Kung isa lang po ang heir, ang tawag po niyan is affidavit of self-adjudication. reklamo sila, pag singil ng, kasi ang minimum po sa tarifa ng IBP Davao City, ang extrajudicial settlement is 10,000. Minimum yun, no? Depende kasi kung minsan makapal, marami, nagataas yun, no? Pero kung simple lang, 10,000. Pero kung isa lang ginagawa is affidavit of self-adjudication. So, gawa din kami ng, singil kami 10,000. Grabe ha po the attorney, affidavit lang ng 10,000. Hindi po, ewan ko bakit term yan, affidavit of self-adjudication. But, yes po, mahal din talaga basta settlement of estate. And remember lang, even if you, the moment you process these documents, no, huwag niyo pong kalimutan na you have to publish that in a newspaper of general circulation for 3 consecutive weeks. Bigay mo ba yung original sa Sunstar? Hindi. Xerox copy lang po ibigay mo. Now, para makamura, ang ginagawa ko, basta kung saan kasi siya namatay, in the area where there is a general circulation ng newspaper na yan, let's say Davao City, punta ako sa Sunstar, hindi ako yung Sunstar na mahal, kay 1.5 man yun. Doon ako sa Sunstar Super Balita. 1,000 lang man. Diba? Makatipid ba? Yung mga technique ganyan ba? As long as it's circulating in Davao City, maraming mga newspaper publications. No? So, pwede kayong lumapit doon. Okay? Take note of that. And itong deed of sale with assumption of mortgage. Now, I have a very important video lecture which I would like you to watch later. May time kayo. Yung pasalo. Ano nga ba ito? Pasalo is assumption of mortgage. Saluin mo ba? Especially if may yung sa pag-ibig 30 years to pay na ikaw ang mo assume. Sa pag-assume mo ngayon yan, merong mga gagawin mo na document is deed of sale with assumption of mortgage. SPA din to get the title. Di ba? Then, you present that to the pag-ibig. Ang pag-ibig says, we will not recognize that, ma'am, that is your private transaction. Kami po, basta as long as you pay us every month sa amortization, we will put the resibo under the name of the awardee ng pag-ibig. Hindi po sa inyo. Pero pwede kayong magbayad. Kaya may SPA man kayo. Hindi bayaran nyo. Ganun. Now, pagdating ng 30 years, fully paid ka na, then now, you would say, okay, sir, can I get now the title kasi may SPA ako? Hindi po. SPA nyo 30 years ago pa po yan, or 20 years ago. We needed an updated SPA. Sir, di ba, alam niyo po, sa leksyon ni Attorney Bato, may expiration yan. What if kung patay na po yung SPA, patay na rin po yung SPA nyo. Patay na yung principal, I'm sorry. Patay na rin yung authority nyo. What if kung comatose and everything, patay na rin po yan. We needed an updated SPA. And second problem, yung deed of sale with assumption of mortgage mo, gagamitin mo, enter mo yun sa BIR to compute the capital gain tax and everything. Nagpilo-pilo ang penalties. Grabing penalties because di pa ka mabayaran mo because 20 or 30 years ago pa yan. Maraming hindi marunong magawa ng proper document kapag pasalo transaction, no? Yung deed of sale with assumption of mortgage. And I'm trying to educate as many people as I can through our free legal forum sa video lectures natin so that they would know, hindi magkamali. Meron kasing technique wherein you have to make what we call an SPA coupled with interest. Yung legit na SPA coupled with interest. Kasi yung SPA coupled with interest na yan, hindi po namamatay yan. Even if mamatay ang principal, even if makomatose, civil interdiction, hindi ano mamamatay. At saka hindi yan siya ma-revoke. Kasi irrevocable special property attorney coupled with interest. Ibig sabihin, may interest ko dun sa property na yon, either financially, may claim ka dun, may stake, by reason of this deed of sale with assumption of mortgage. And therefore, it will not die. So yung SPA na yon, pagdating ng 30 years at fully paid ka na, pagpakita mo yan sa pag-ibig, O no questions asked yan sila. Bigay ka lang title sa'yo. Because it never dies. And how about naman sa deed of sale? And if the SPA coupled with interest gives you an authority to sell the property to any person, including to yourself, pwede po yun. So, pwede kang gumawa ng SPA based on that SPA coupled with interest that doesn't die. Maria de la Cruz, as attorney-in-fact of Juan Reyes, sells this property to Maria de la Cruz. Kasi authorized ka man. Is that allowed? Yes. Minsan may registry of deeds friend ako na naguluhan. Pwede ba ni ba? Naku, yes. Cite ko yung kanyang base. Ay, oo, pwede. Pwede pala. So with that, I'm going to show a video lecture sa inyo, no? On this SPA. Gusto ko talagang i-discuss sa inyo itong special power of attorney. Very, very important po ito. Meron po akong ginawa na video lecture on this.
Battery 100%. Connected to PHEOSAI 620.
Para maka-break din tayo konti. Okay, I would like you to watch this. Good morning. Welcome back to our lecture room. Ngayong araw na ito, pag-usapan natin isang klaseng SPA. Isang klaseng SPA na hindi nag-e-expire. Meron bang ganon? Yes po, meron. And we will continue after this short intro. Okay. Ang sinasabi kong SPA po, ito pong SPA na ito na walang expiration date. Meron pa lang ganun, attorney? Yes, meron po. Pero bago niyan, pag-usapan natin, ano ba ang basihan bakit pwede tayong magbigay ng special power of attorney sa isang tao? At bakit ito tinatanggap? Let's say, mag-transact tayo sa government, may SPA, government agencies, mag-transact tayo sa ibang tao, meron ng SPA yung katransact natin, pwede na. Bakit? Saan ang galing niyang authority na yan para magbigay ng SPA? Alright? So, ang basihan po natin dito ay itong Civil Code of the Philippines. Yes, meron po tayong batas at yan po is Article 1868 by the Contract of Agency, sabi ng Civil Code of the Philippines, that a person, yung attorney-in-fact, binds himself to render some service or to do something. Gagawa siya in favor or on behalf of the principal with his consent or authority. Now, do not confuse yourself ito sa real estate service practitioner na licensed broker or salesperson o yung ginatawag nilang ahente ng lupa, because what they have is an authority to sell. Yung authority to sell nila is to look for a buyer lang para ibenta yung property nila. Now, ang ahente po ng lupa is pwedeng ATS lang hawak niya, authority to sell, or pwede rin siyang gawing attorney-in-fact para pumirma sa deed of sale. But not always na meron silang SPA. Hawak nila ATS lang. Yun po nga hanapin natin kapag mag-represent sila na binibenta yung property to. Meron ka about authority to sell? Yes. Oh, nandyan ba yung may-ari? Yes. Kung saan ang may-ari, meron bang SPA? Yes. Sino ang binigyan ng SPA? ito po ang binigyan ng SPA ang anak niya, or ako po binigyan niya. Tingnan natin yung SPA mo. So, yung SPA na yan, hindi lang usually sa pagbebenta. Marami pong purpose ang SPA, no? So, like this one, it is a written undertaking by someone giving authority to another. And the undertaking of the other one to perform kung ano po yung binigay na authority sa kanya ng principal. Yan po ang special power of attorney. So, special power of attorney to get medical records, special power of attorney to connect light, utilities, water connection, cable, internet, tapos yung magkuha ng mga PRC license, alam mo, mga things like that, mag-process, mag-follow up sa SSS. Those are the special power of attorneys, the different kinds. So, it also includes a special power of attorney to sell, lease, and mortgage. Yan ang mga very important na special power of attorney. Napaka-ingat po talaga tayo dyan. At yan po ang ating babantayan because this involves transmission of right. Yung po natatransmit po yung karapatan ng isang tao sa ibang tao, yan po ang pinakamaingat na mga dokumento. Ingatan po natin at pag-aralan, suriin mabuti, conduct tayo ng due diligence. Alright, so going further, ito pong special power of attorney, meron tayong principal. Yung principal yung nagbibigay ng authority or power doon sa attorney in fact. Okay, it must be in writing first and consensual. Ibig sabihin, kung ang principal magbibigay ng authority sa attorney in fact, dapat with his consent on conformity as well as the attorney in fact kung i-perform ba niya yung services or to do something in favor ng principal. Yan, consensual and must be in writing. And in most cases, which is better talaga, is that it must be notarized. Now, meron kasing mga authorization or SPA na hindi kailangan notarized. So, mas simple to get this paper, to get authorization to claim piece of document on this private institution. But in almost all government agencies na mag-transact tayo, Registry of Deeds, City Assessors, Bureau of Internal Revenue, all government agencies, even sa PRC, kailangan po ng notarized special power of attorney when you give somebody an authority na mag-transact in your behalf. Kailangan po special power of attorney and it must be signed by you as well as notarized by the notary public. Kasi bakit po? Ang purpose po niyan is that maging public document. At pag public document ito, ibig sabihin, tatanggapin na yan ng mga government agencies. Pag hindi public document, it's a private document, they may reject it. Okay? Bakit importante public document? Because as it said, this carries a presumption of regularity that it passes through the scrutiny of the notary public. Yan ang po ang purpose niyan. So it is the presumption of regularity and validity. Kaya tinatanggap ng government agencies, especially on those transactions, merong involvement ng transmission of rights, yung paglipat ng mga karapatan from one person to another person. Yan po siya. So remember, it should be a legitimate notary public ha. Mayroong law office at of course mayroong nagbayad siya ng IBP dues, may MCLK siya, mandatory continuing legal education, nagsaseminar siya, meron siyang notarial commission number, nag-apply siya for 2 years, then every 2 years kasi nire-renew yan, tapos meron siyang professional tax receipt na bayad, tapos meron yung IBP dues siya na bayaran niya, etc. And of course, malalaman nyo rin na very legit yan siya kasi papipirmahin po kayo sa libro nito sa notarial register. Meron po kasi kaming notarial register. Itong notarial register, doon namin nire-record kung anong document number siya, anong page number, book number, series of 2022. Nilalagay namin ang pangalan ng principal at attorney in fact, pinapapirma kayo sa ibabaw. Nilalagay namin kung anong ID ang binigay nyo sa amin at pinakita para ma-prove ang kanyang pagkatao. Kung kayo ba talaga yung parties, no? Witnesses address doon, lahat nakalagay doon. Pati yung fees na binayad ninyo, ilalagay namin doon sa notarial register at sinasubmit po namin yan sa korte. Yun po ang dapat. Now, ina-emphasize ko na very important kasi especially if SPA po sa sale, lease, and mortgages at saka iba pang ways na magkaroon ng transmission of rights, pag i-transmit yung right sa isang from one person to another, very important po na doon po talaga sa legit na notary public ha. Huwag po doon sa tabi-tabi o bangketa. Alright. Now, ang problem is that meron na tayong SPA. But the problem is SPA, pag ibinigay po yan siya ng principal sa attorney in fact, may hangganan yan siya, namamatayan siya. And ano ba yung mga ways na ang agency is extinguished? Ito. Ang ways that the agency extinguished, number one, of course, revocation. Sabi niya, ayaw ko na. Is-revoke mo na yung authority na binigay ko sa attorney in fact. Stop. Then, it's revoked. Then you have no power already to represent me. How does it is being revoked? It can be revoked by making a revocation of special perpetuity. Ipanotarize din sa abogado. Then, bigyan siya ng copy na furnish siya na your authority is revoked. Now, if that SPA has been annotated on the title, ipa-annotate mo rin yung revocation of special perpetuity. Alright, so another way of how agency is extinguished is itong death nung principal or even the agent, no? And of course, yung civil interdiction. Ano ba yung civil interdiction? When the principal has been sentenced with final judgment that carries imprisonment and civil interdiction. Ibig sabihin, hindi siya pwede magboto, hindi siya pwede magbenta ng property, hindi siya pwede mag-manage ng properties, etc. Therefore, that is a penalty with civil interdiction. Automatic, kung may SPA ka, patay na yung SPA na yun. Yung attorney in fact, wala na siyang authority to represent you. O, vice versa yan, ha? And of course, kung insanity. So ang pinasa lang kasi ng principal sa attorney in fact, yung authority na yon, at it would appear na dapat is always siyang sane. Now, if he becomes insane, so hindi na siya makapagpasa ng authority. Mentally incapacitated na siya. And therefore, the agency is extinguished. No? And other forms of defects sa mental faculties, katulad ng nakoma ng tao, hindi na siya pwede makapag-transmit ng authority sa attorney in fact. Diba ka naman, ang gagawin ninyo, kukuha kayo ng tammark, tammark yung sulapit, tapos panotaryo yun, hindi pwede. Wala pong lawyer mag-notarize niyan. Kasi unless you go to yung mga unscrupulous notary public kuno na hindi namang notary public, yung mga peke, pwede nyo. Pero sa mga legit na notary public, we do not notarize that. We're afraid to notarize that. We have to know kung yung tao is talagang mentally capacitated. And besides yung tammark, meron kaming rules sa notarial practice on how to deal with tammark na people. Magre-require pa kami ng 2 disinterested witness na nakita na nagtammark talaga siya sa harapan namin. Okay, so very careful kami pagdating sa mga bagay na yan. So, at kayo rin po, kung may nakita kayo na tammark na SPA, klaruhin nyo. Mabuti pang isang guni nyo sa abogado, ipacheck nyo kung legit ba yung tammark na ginawa. Do not rely on the representation nung nagtatransact sa inyo na, legit yan, okay, lalo na sa bentahan ng lupa, yung may transmission of rights ng lupa. At ako, delikado po yan. Alright, so, the special power of attorney. Now, klase nga ng special power of attorney na delikado is kapag yung may sale. Yan. You have to be very careful pag meron pong special power of attorney na sale. You have to scrutinize it. Iklaro po ninyo yan. Tapos, ano pa? Yung mga may transmission of rights, katulad ng lease, lalo na pag long-term lease, at saka yung mortgages and others, no? Pag mga ganyang tasing SPA, tingnan ninyo po na mabuti yan. And scrutinize, o kung pwede, isang guni nyo sa abogado kung effective pa ba yan. Now, I'll give you an example. For example, ang date ng special power of attorney is August 12, 2012. Ano na ngayon? 2022. That would be mean 10 years na. So, if I'm the lawyer, tapos, let's say, the attorney in fact says, sir, may authority ako na magbenta or mag-lease o mag-mortgage. Lagay na natin, magbenta muna. Hihingi ako ng updated SPA niyan. Sabihin ko, sandali, ulitin natin ito. Kasi baka 10 years ago, hindi ko na alam ang mental state or faculty nung nagbigay ng authority ito sa'yo. At saka kailangan ko siyang kausapin. Saan ba siya ngayon? Sabi niya, sir, nasa Amerika. Nasa Amerika. So, kailangan ko ng apostolized SPA or kundi culturalized SPA. Padala mo dito. And I need to talk to that person. Titingnan ko kung mentally capable pa siya. And talaga bang
hindi pa niya na-revoke yan. O baka patay na yun, di ba? O, di ba? So, along the way, makikita natin ang problema. In fact, I have an example before that 10 years na SPA, nung tinanong ko doon, sabi ko nasa stage 4 di kausapin ko yung nasa stage na yun. Pagtawag namin, patay na pala. Nakausap namin ang heirs. Sabi ng heirs, ay, hindi po yan, patay na po yung SPA niyan, wala. Hindi na, kasi patay na si dad. So, ibig sabihin, the SPA also dead, no? Expired, extinguished, no, nada. Wala na yun siyang effect. So, if you want to proceed with the transaction, kasi ito, example ko, sale yun. So, I got a new SPA from the children kasi gusto naman din talaga na i-proceed ang pagbenta. Pero iba na. XPA to extrajudicially settle the estate kasi patay na yung papa nila plus sell to the attorney in fact. Okay, ako ang gawa. Email ko, pinadala ko sa kanila, pinapost nila, tapos ni-FedEx nila sa akin. Then with that, I am absolutely certain na sakto na yung SPA. Updated na siya sa current but ang heirs na ang pumirma. Okay, yun po, no? Maraming mga mistakes dito. For example, talaga, itong number one problem natin, itong transaction na ito sa Pag-ibig. So, ito si seller, Juan de la Cruz, no? May-ari siya ng Pag-ibig property at ang buyer si Pedro Reyes, nakabili siya. Ang transaction po nila ay ganito. Okay, deed of sale with assumption of mortgage. So, pasalo, no? And number 2, assumption price is 1 million. Tapos, ang balance loan at Pag-ibig is, that's 3 million, ha? 3 million. Okay, yan ang balance niya. At ang terms of payment is 30 years to pay, monthly amortization. So, nag-execute po sila ng deed of sale with assumption of mortgage at saka special power of attorney. Now, punta si buyer doon sa Pag-ibig at sabi niya, "Sir, could you recognize me na ako na po yung bagong nag-assume kasi ako na po magbabayad?" Sabihin ng Pag-ibig, "No, we will not recognize your transaction with the seller ni Juan de la Cruz." Bakit po? Kasi that is your private transaction. Yun po sasabihin nila. Ang gawin mo po is kung yung continue is magbabayad lang kayo niyan ng monthly hanggang umabot po yung 30 years. Then from that time, pwede nyo na kunin ang title. May SPA naman kayo. Now, the only way that we could entertain you is if this will be transferred under your name na ikaw ang original borrower, but it will take time kasi ililipat ang title sa pangalan mo muna, gagastos ka. Tapos, bago namin tatanggapin bago namin i-release itong title is dapat i-fully paid. Ang gulo. So, having said that, hindi sila tatanggap niyan. Sabihin ng Pag-ibig, "Oops, that transaction is between the two of you. Pagbayad tayo sa monthly amortization under the name ni Juan de la Cruz. Pwede natin ipabar na Pedro Reyes sa tabi para to prove na ikaw nagbabayad. But at the end of the day, pagtapos ng bayaran nito, isa sa uli namin itong mga title, cancellation of documents in favor kay Juan de la Cruz. So, be ready with a special power of attorney." So, sabi ni buyer, okay lang. Meron naman akong SPA dito. Isip-isip niya. Okay. So, lumipas ang panahon. Umabot na ng 30 years. So, sobrang antay niya. Wow, 30 years na. Fully paid na ako. So, punta na ako sa Pag-ibig. Okay. Dala-dala niya ang deed of sale with assumption of mortgage, pati yung SPA 30 years ago. And chinek po ng taga-Pag-ibig. Sabi ng taga-Pag-ibig, "Sorry po sir, itong SPA na 30 years ago, kailangan po namin ng updated one." Sabi naman ni Pedro Reyes, "Bakit? Di ba yung SPA na yan, I have the authority to claim the title, I have the authority to receive the cancellation documents." Sabi ng taga-Pag-ibig, "Yes po. Pero how sure are we that for the 30 years ago, nabuhay pa itong yung principal, yung nagbigay ng authority sa inyo, yung seller na si Juan de la Cruz?" Kasi kung basic po sa batas natin, the death of the principal extinguishes the agency. Alam niya, no? Note siya ng vlog natin. Tapos, or the death, civil interdiction, or revocation. Yan ang problema, sir. So, kailangan natin updated. No, ganun ba? Updated SPA? What? So, talagang sakit ang ulo. Kahit po, ano pong beg ninyo, no? Request nyo, umiyak naman kayo sa harapan ng taga-Pag-ibig ng dugo. Wala po yan siyang magawa at sabihin niyo, sir, sorry, ito po ang policy at regulation po namin. So these are the common mistakes that we have. Now, meron ba cure? Meron, mahirap, medyo madugo na usapan na paano pa siya i-cure. Pero there is still a very there is still a light at the end of the tunnel, pero hindi naman siya dumalaliwanag, no? But it can still be done. Like, for example, ganito ang advice ko, okay, you look for the seller. And sir, patay na po. And then you look for the heirs. Gagawa tayo ng bagong SPA para at least makuha natin yan. Yes, sir. Paano kung na-contact? Let's say, kahit nabuhay sa seller, ayaw na mag-cooperate or hihingi ng konting pera. Di ba? So, that would be added expense sa'yo. Tapos, second yan, magagawa ka na ng bagong deed of sale na naman. Kasi yung deed of sale with assumption of mortgage, pag ginamit mo yun siya, ang penalty doon 30 years ago pa. Paano ang penalty mo per year niyan sa capital gain tax at documentary stamp tax? No? So, magre-request ka na naman ulit sa seller ng new deed of sale or sa heirs kung patay na siya. Pero bayad ka na naman ng ng estate tax kasi extrajudicial settlement with sale. Paano kung naman sila ng payment? Added cost sa inyo. At saka, it would be much troublesome and hassle and stressful and anxiety niyan sa iyo sobra. So, well, that is the cure. Difficult, but it is possible. But it is still best if meron tayong tinatawag na prevention is better than cure. Okay. So we prevent it from happening. And how do we do that? Ito po. Ang gagawin natin is dapat doon pa lang sa simula, no? Para po sa inyo ito, sa simula pa kayo mag-assume or magsalo ng isang loan obligation kahit sa pag-ibig or sa in-house financing or any developers for that matter sa bank, you have to create what we call or execute what we call a irrevocable special power of attorney coupled with interest. Yan ang dapat gagawin natin. And take note that in this irrevocable special power of attorney coupled with interest, the buyer here is authorized irrevocably. Ibig sabihin, hindi na pwedeng i-revoke, punitin, or stop, no? That is final, cannot be revoked, no? Number one is to, of course, make full payment of the mortgage obligation and all fees, amortization, to claim or receive the duplicate titles, yung mga cancellation documents, kasi i-release natin yan, no? Kasi naka-annotate dun yung prenda. Sign papers, documents, and necessary to consummate the authority. And of course, dapat nakalagay po dito is may authority po kayo to sell the property to any person, including to yourself as the buyer. So, parang mag-a-act ka na ngayon na ikaw ang seller papunta sa'yo. Yan. At a price you may deem solely determined. Ikaw lang mag-determine at any price na ilalagay mo. Yon, maganda yan. Sabihin nyo, sir, paano kung mamatay po? Wala na rin. Ineffective na rin yung SPA na yan. Hindi po, kasi it is a SPA coupled with interest. At ilalagay nyo po ito sa SPA that this agency shall remain in full force and effect even after the death, act, or condition of the principal, yung mental capacity niya, since it has been constituted for and in the interest of the attorney in fact. So, ano po ang interest ng attorney in fact? Is that yung deed of sale with assumption of mortgage. So, yun po ilalagay doon because that is an assumption of mortgage. If it is clearly established na ginawa yung SPA yan for the interest of the attorney in fact, dahil meron siyang interest doon sa lupa, sa property na yon, pwede po itong special power of attorney coupled with interest. Okay? So that is how to prevent the problem from happening. Okay. Now, warning lang po, caveat, no, to everyone else. Not at all times pwede mo gamitin yung word na coupled with interest sa SPA. Kasi iba kasi nakikita ko SPA coupled with interest, hindi naman nakastate doon na it must be constituted for and in the interest of the attorney. In fact, hindi nakasulat doon. Kasi dapat ilagay doon bakit naging interesado ang attorney in fact doon sa property na yan. Ano ang interest niya? I-establish mo doon that it was constituted because of a deed of sale with assumption of mortgage. It was considered for his interest because may loan yung seller at pambayad niya ang proceeds ng property na yan in favor sa buyer at sa attorney in fact. Yan. So, ibig sabihin, meron po interest doon sa attorney in fact para maging coupled with interest. No? So, take note of that. Irrevocable, special power of attorney, coupled with interest. Yung klarong statement na totoong coupled with interest. Alright, so I hope you learned again something during our video today. And if you like this video, do not forget to click, subscribe, and hit the notification bell for future video updates. Again, thank you. Danke, shukran, maraming salamat po. See you again next time.
So, ayan, no? That is how we should deal with a SPA po, no? So, yan po siya. Now, take note that tapos na ba tayo? Kung ganon. Meaning is that tapos na ba ang due diligence natin? That is the $1,000,000 question. Actually, I would like you to answer me kung ano ba ang kulang natin. Can anybody tell me ano ba bang kulang natin? Wala na yata. Tulog na yata. O nagkain na kayo. Hindi na kayo magsagot Ano ba ang kulang natin?
Aking kaon.
Ano pa ang kulang? Let me know kung ano pa ang kulang.
Yes, anybody from the audience or sa chat box, meron pa yung mga questions, attorney, but then
No, actually, ang tanong ko muna, ma'am, hindi
mamaya pa po ba?
mamaya pa. Ang tanong ko, ano pa bang kulang natin sa due diligence? Meron pang isa.
Yeah, is there any?
Sige, ako na lang magsagot. Ang kulang natin is itong
Welcome back to our lecture.
ito yung tawag nating relocation survey. Importante po itong relocation survey because you have to know the meets and bounds of the property, especially if kapag hindi nasa gated or subdivision. No? For example, okay lang kung sa Santa Lucia, Santos Lan, North Crest sa subdivision nila kasi talagang fit talaga ang pag-subscribe niyan. But what if nagbili ka in the middle of the area in Davao City, dyan sa may Jacinto, di ba? What if kung mayroong mga encroachment, overlapping of boundaries? So, you need to conduct what we call a relocation survey. Alright? So, itong relocation survey is very important. Okay. Now, meron akong video lecture na nakita ko yung old one, no? Just bear with me with this old lecture ko. And I would like you, again, to watch this video lecture for your guidance. Wait a minute. Hindi mag-play. Good morning, guys. Welcome back to our lecture channel. Today, we are going to discuss a very important topic, itong ocular inspection of the property. And the question are as follows. Why do we need ocular inspection? Number 2, what are the possible things or matters that you will discover during ocular inspection? Maybe these are problematic things or matters. And how would you deal with it? If you really want to purchase the property, merong mga remedies tayo. And pag-uusapan natin lahat ng yan sa ating video lecture series. But first, we define ocular inspection. Literally, ang ibig sabihin ng ocular inspection is to use the eyes in looking at or in inspecting something. Ibig sabihin, you just go to the property and check the property physically.
through your eyes. Kung hindi po kayo makapunta, send a representative. But take note, that representative must know what he is inspecting or looking at. And later, I will be discussing to you the things that you should look during the conduct of ocular inspection. But first, I will assume that before we conduct ocular inspection, you have already established or determined the proof of ownership of the seller. If it is a titled property, I expect that you already have this certified true copy of the title. You already have the zoning classification of the property. And if it is not titled, that you have seen the tax declaration. And of course, you have already secured a certification from the sender that it is alienable and disposable. Second, and finally, you have already established the identity of the seller. Take note that these 1 and 2, we have already discussed this in our previous video lectures. Now, if it is your first time to watch this video, kindly check the past and previous video lectures so that you could easily understand what we are going to talk on later. So, what are the things that we are going to check during the conduct of ocular inspection? Wag na wag po natin itong kalimutan. I will enumerate the things that I believe that are very, very important. Number 1, check who is in possession of the property. Baka kasi may mga ibang tao doon. May ibang nakapossession sa property. Take note that a seller, when selling a property, should be the owner of the property. And if he is the owner of the property, one of his rights is possession. So establish first if he is in possession of the property. Number 2 thing that you should remember during the conduct of ocular inspection. Are there other settlers? When I mean settlers, they may be legitimate settlers or illegal settlers. Legitimate settlers, baka mga relatives ng seller. But you have to talk to them. Why are you still here? I'm going to buy the property. Ganun ba? But how about if the settlers are what we call informal settlers? What are the remedies if really you want to purchase the property? Number 3 that you should remember, are there tenants? Now, tenants may be agricultural tenants under the Comprehensive Agrarian Reform Law or sa the rules natin. And meron din klaseng tenants na lessees, yung nagre-rent, no? In residential or commercial properties or even agricultural properties. Now, these people, when they have this contract of lease, they have certain rights. And you have to check this. Number 4, are there easements? Right of way, easements relating to waters, party wall. Kasi pag bumili ka ng property, posibleng existing itong mga bagay na ito. Or sa right of way, baka walang right of way. So, you have to check on that. Are there accessions involved? Ano ito accessions? Ano yung nandun sa loob ng lupa? Meron bang tanim? Meron bang puno? Meron bang pan? Those are the things that you should know if you want to buy the property. Are there encroachments? Ito very important. Dito, maraming cases na file support tapos nagkakagulo, nag-aaway ang magkakapitbahay, pati yung buyer and seller because of this. Because encroachments can be visible to the eye and can be not visible to the eye. So we have to remedy on how to look to check for encroachments on the property that you're going to purchase. Now, take note that there are 2 kinds of encroachment. Encroachment on property rights, yung karapatan mo sa lupa. Being an owner, somebody encroach on your property rights. And encroachment on the property itself, doon talaga sa lupa mismo, sa property, talagang pinasok. Pag-aaralan natin yan. And finally, road widening, baka meron. Or undergoing road widening or tapos na or about to, you have to know these things. Baka existing yan siya doon sa property na bibiliin mo. Transmission line ng Nabucco. Yan. Now, these things that are important matters that you should check during your conduct of ocular inspection, these are the important things that I think very important. And in the next video lectures that we're going to do, each of these things we are going to dissect and discuss separately. So wait for that video uploads that we are going to do. This will be an exciting discussion on all these things because it involves actual scenarios to be presented during the next video lectures. Alright, so proceed. And before we close, remember to conduct due diligence. What is due diligence? Due diligence is the exercise of care or investigation that a buyer is normally expected to do before entering into a real estate sales transaction with the seller. So, investigation, inspection, ocular inspection is part of due diligence. So, we have discussed already the know the proof of ownership. We have already discussed know how to verify a land title. We have discussed already know the seller. Now, we are under number 4, the conduct of ocular inspection. Marami po tayong i-discuss dito sa number 4 na ito. And I will share everything to you. Wala akong give everything to you. And number 5, know the taxes and legal expenses later. We are going to discuss that after number 4. And find a real notary public. So guys, I will be back soon. And please keep in touch and thank you so much for watching this video, initial video presentation for our topic, ocular inspection, which will be having many video lectures. Because, good morning guys.
All right,
Welcome back to...
So medyo I'm happy to see my lecture ba na andyan pa pala yung old lecture ko, no? So yun po ang tapos natin sa documentation and due diligence, and now I am ready to answer questions kung meron pong mga katanungan. I'll stop sharing already.
All right, thank you. From the chat box, attorney, we have few questions here. I'll start with from Ruby Paano.
Sige po.
Medyo out of topic daw po, but here's her question. Masali ba sa years ang mga illegitimate child? Paano pagpatay na din ang first wife? Automatic ba ang second wife? Yan po yung tanong ni attorney.
Okay. Well, actually, ang rule is that ang illegitimate child nung namatay, they are considered as compulsory heir. Compulsory heir yan sila. Wala tayong magawa dyan. No? They are actually part, no? As of the estate. Now, yung sinasabi kasing first and second wife, no? Ang rule kasi is that kung merong first wife, no, nas namatay, so may mga anak siya doon, under the law is that you must settle the estate bago ka mag-asawa sana. Actually, sa family code, 6 months dapat ma-settle mo yan. Otherwise, kung hindi mo i-settle, automatic complete separation of property po sa second marriage ninyo. However, even if ganon, kung ang namatay ang husband later on, lahat po ng compulsory heirs niya, including po doon, sa estate lang niya, including po doon sa first wife, magiging part. So, ang magiging heirs niyan would be the second wife. Tanggalin mo na yung 50% ni second wife, no? Tapos yung 50% na naiiwan doon sa husband, may 1 share si second wife. Tapos yung mga anak nila, tapos yung mga anak niya sa first. Yun lang ang paghatian, yun lang sa side ng husband na namatay. Alright?
Alright. Thank you, attorney. I hope, Ruby Fano, your question was clearly addressed. Our next question is from Rosario Benitez. May claim ba ang mga foreign spouses sa real properties ng Filipino citizen, like while married or after divorce?
Well, while married po, kapag lupa, wala silang share kasi only citizens of the Philippines can own real property, di ba? However, if mauna mamatay si Filipino or Filipina wife, magkakaroon sila ng ownership share by way of intestate succession, one share, no? Yan lang exception. Now, that is during the marriage. And if it is a condominium unit, mayroon talaga siyang 50% share kasi foreigners are allowed to own condos, right? Now, after divorce, during the divorce is that malagay man doon sa divorce, ano ang situation nila doon sa property. Kung napag-usapan, let's say, sa divorce that na-waive ni foreigner or kanya ito, kanya ganon, especially if it's a mutual divorce, no, done, may identify kung kanino mapupunta yung property, ma-adjudicate ba. Now, if it is silent as to the adjudication, it remains to be a co-ownership with respect to the properties na pwedeng mag-own si foreigner, like the condo. Pero doon sa, doon sa land, hindi. Kahit na ano pang sabihin doon is that would be the exclusive property of the Filipino or Filipino wife. Alright?
Yes, thank you, attorney, for that. Rosario Benitez, I hope that's clear already. Meron pa tayong question from Juliet Usadan. This goes like this. The parents po hinati po lupa sa kanyang mga anak. One of their daughters kinasal ng 2012. And may kanya ng partner. Tapos, just last year, hinati po, naghiwalay pala sila ng 2018. And then, tapos lahat, yung last year, hinati po at pinatituluhan ng magulang. Ang question po niya is, may karapatan po ba si separated husband sa lupa ng parents ni wife?
Yung property, kasi I would assume na kinasal sa 2012, so absolute community, wala silang conjugal partners, wala silang prenuptial, no? So it's absolute community. Ibig sabihin, they will own all the properties, no? Now, ang kalahati nun, sa kanya, kay co-own siya, no? Now, except that, kung during the marriage po, is that meron pong natanggap na mana or merong natanggap na donation yung isang wife, no? Yung wife, no? Based on your question. So, in that particular case, that is the exclusive property of the wife. She can do anything she want with that. She can sell it, mortgage, lease, without the marital consent nung husband because exclusive niya.
Husband.
Ganyan lang ang pong technique niyan.
Okay. Thank you, attorney, again.
Yes.
From Helen Estilo, I don't, if it's NGP, the annotation of the NGP, there is a portion of 3,000 square meters. Then the owner or the landowner paid the NGP to her. Then there is annotation from NGP. Can you explain again, attorney?
Yung NGP, yan yung National Grid Corporation, Power Corporation. No?
Right.
They are actually a government-owned and controlled corporation by the government. And therefore, they could expropriate, no? Kasi for public use nga, kailangan magdaan yung transmission line para sa kuryente. And before they do that, they also pay, no, the landowners of the disturbance that they committed. No? In fact, one of the disturbances that they made would be na even if the transmission line is mataas, doon sa ilalim nun, hindi ka pwede magtayo ng mga bahay eh. Kahit sabihin mo may vacant space, no? The most that you could do is magtanim ka na ng gulay doon. So, ibig sabihin, yun ang covered sa disturbance, no? And they have to pay you what we call just compensation for that, no? The determination of which sa market value po yan. Kung sino po ang may-ari, let's say, nandyan na yan, naka-annotate na, at nabayaran na yung previous owner, kaya na yun, wala na yun. Pero kung binenta tapos hindi pa na-claim yan, so yung nakabili, pwede niya i-claim yun sa National Grid and Power Corporation. Okay? I hope I answered your
Okay.
question.
Thank you again. We still have more questions, attorney. Are you still okay with that?
Of course.
Well, from Rovelyn De Lemos, ano po ba daw dapat gawin sa isang title na under the name of their deceased father or parents na ipinamana sa eldest na anak? May agreement naman daw po ang silang magkakapatid na di na sila makikihati sa property na ipinamana. Ano po ba dapat gawin ng eldest na nagmana?
Well, take note ha, pag sinabing pinamana sa kanya, is that there must be last will and testament for that matter. Hindi po pwede verbal in order to be valid, no? So, if pinamana sa kanya yun, they have to respect that kung may last will and testament. And therefore, kung hindi naman, the rule is that kung merong last will and testament, dapat ipaprobate yan sa court, no? And the court will approve. Pero, kung hindi naman nag-object yung mga kapatid doon sa last will and testament na wala naman talagang tinatawag na undue influence or fraud in paggawa ng last will and testament, gawa na lang sila ng extrajudicial settlement. Sundin lang nila yung nakasaad doon sa last will and testament.
Alright, thank you. From Annalie Eugenio, attorney, makikita mo ba sa death cert sa parents kung ilan lahat ang mga anak niyo po? I think wala naman.
Hindi po, hindi makita yan. Hindi
And
po
yes,
makita.
from Sheila Kuyab. Sir, pila ka months, I think na-answer na ito kanina kasi we have discussed already the special power of attorney. Yung pila ka months daw valid ang SPA and yung, especially yung nasa abroad yung seller.
Yes.
Yung nag-execute ng SPA.
Yes po.
So yes, you have already go. English Data Privacy Act, how to get any document from ROD, assessors offices and the likes if your purpose is to obtain correct and proper information with regards to pertinent documents.
Alright, ang data...
Kailangan ba ng...
Okay. Ang Data Privacy Act kasi
Yeah.
concerns with a matter or a data that is private. Now, there are documents that are considered as public documents open to the public and public documents that is kept for private and personalities who are directly interested on that. No? Example ng mga ganyang klaseng public document na kailangan talagang ang magkuha is yung may SPA or magkuha mismo ang kumbaga sa Bisaya patagtungod, no? Yung talagang may kailangan is yung PSA, mga birth certificate, death certificates. It's a matter of private kasi ano. Yung mga details kasi ng birth, details na kailan, sino, papa, mama, and everything, that would pertain nung doon sa mga interested party. Now, with respect naman sa tax declarations and sa city assessors, that is a public document. You could get it without any SPA, no? Because you can even get a statement of account under this named person, kung ano pa hindi nababayaran, so that they determine how much ang land holding niya, you can do that. And I would also say that in the Registry of Deeds, my personal opinion is that this is a public document ready for the public. Anybody could get it. However, because of the unscrupulous requesting of certified true copies by the colorum or the illegitimate agentes, no? Basta they will just get this CTC and offer it for sale without any ETS and everything. Naging stricto po ang Registry of Deeds that it will be certified true copy of the title can only be requested by the owner, the registered owner, or through an SPA. However, as real estate practitioners, tayo po, real estate brokers and lawyers, we could write a letter and ask for a certified true copy because as practitioners, we are allowed to ask from it. Gawa ka lang ng letter and they will keep that. No? So, allowed po tayo. Lagyan nyo lang yung REB number. And sometimes ako, ina-attach ko yung aking yung PRC ID or yung aking lawyer's ID to get it because it is for legal and real estate transaction. Mga ganyan na purposes, no? So that's how it is, no? Yun ang aking 2 cents worth on your questions.
Thank you, Attorney. And another question from Diana Ramos. Kapag po ang tax debt na lot is being paid by a tenant for decades, receipts show payer's name is tenant, but money paid is from heirs. Is it true that the tenant can claim ownership of the lot?
Of course not. Because ang tenant kasi is tenant. Lessee lang siya. Kumbaga, technically speaking, ang tenant po ngayon sa batas natin, ang tawag sa kanya is agricultural lessee. Hindi pwede siya may-ari ng property. In fact, if you will see my previous video lectures, may discussions ako on these rights ng mga tenants, no? Wala na po yung tersera, yung 1/3, 2/3 na sharing system. Wala na po yan, no? In fact, kung nandyan pa kayo sa system na ngayon, kayo ang may-owner or kayo ang tenant, you could even file a petition sa DARAB to determine the magkano ang agricultural leasehold, no? Kasi magbabayad ka talaga pera niyan. Depende, monthly, quarterly, and everything. And in fact, ang tenant po, hindi po siya pwedeng siya lang mag-decide kung anong itanim. Pwedeng siya lang mag-decide everything. No. It must be in conformity with the registered owner. Yung mga sound agricultural practices. Pag hindi i-follow ng tenant, pwede siya ipa-eject. Imagine, you could eject a tenant. Ibig sabihin, he is just a lessee. He is not the owner. However, if you sell the property, if you're the non-owner, you want to sell the property, you can do that. However, you must offer it first to the tenant. Yun ang may right of first refusal. Automatic, hindi na sa contract, but by law. Meron silang right of preemption, ang tawag niyan. Now, kung binenta po na na walang new gi-offer sa kanya, meron po siyang right of redemption. So, pwede niyang i-redeem yan siya, no? All of these are guaranteed sa kanya. Sabihin natin wala siyang pera, pwede po siya magpalapit po sa land bank for that purpose, no? Because that is an entitlement. Pero, in most cases, kung sabihin niya instead na i-offer sa akin, paalisin ako and everything, actually hindi siya entitled sa disturbance compensation unless kung yung agricultural property is gagawing i-reclassify to siya into residential para gawing i-develop siya for residential purposes by a developer na registered sa DSUD. And in that case, meron po siyang disturbance compensation. Alright?
Okay, thank you. Again from Nobilita Pelotea. Attorney, sa title, pwede ba maka-annotate kahit di ka pa nakatapos magbayad? It's a rollout daw. Dahil di na pwede ma-pursue magbayad due to delinquent status of the lot. Annotation na pwede ba naming na magpa-refund or may claim kami sa association? Di kasi nakikipag-coordinate na ang nag-handle na president.
Yeah, you could,
at ayaw kami harapin.
yes, you could execute an affidavit of adverse claim and have it annotated on the title.
Another question pa, Attorney Hanggang.
Yes, go ahead.
Hello, Attorney. Sorry if hindi ko masyado nakuha kanina from Sarah May Caballes. Nag-assume po ako ng house and lot sa Pag-ibig, pero under pa po sa owner ang Pag-ibig, 30 years to pay. Naka-SPA na ako. Na-mention nyo kanina na on 30 years, magiging ng latest SPA si Pag-ibig. What if namatay yung owner?
Kaya nga po, as I said from my video lecture, kung nandyan pa yung owner ngayon, magpagawa na kayo ng SPA na hindi namamatay. Diba? I-discuss ko na yan, yung SPA na hindi namamatay. Ano bang yung SPA na hindi namamatay?
Irrevocable.
Irrevocable, special power of attorney, coupled with interest. Okay. Sana, panoodin nyo ulit yung video lecture. Anyway, nandyan naman sa channel natin. And this one is also recorded live no, sa YouTube ngayon.
Okay. I hope you listen. Yun na lang po. Titingnan nyo po yun kasi it was already mentioned a while ago. Ngayon, from Villa Paz, Christine May. Attorney, ang husband ba na makonsider na heir ng wife na namatay, considering kinasal sila before August 13, 1988, before the Civil Code?
Well, before the Civil Code, ang rule is Spanish Civil Code, no? Ang gagamitin. And actually, ang Civil Code natin is patterned from the Spanish Civil Code. I am not an expert on the Spanish Civil Code kasi wala namang use, hindi ako pinag-aralan masyado yan. But I would assume that same lang ang rule. Heir po siya sa kanyang spouse.
Okay. From Mirasol Opalia, attorney, tanong ko po, may namana kami without will kasi namatay na sila mga lola at lolo namin, tapos patay na rin mama at papa namin. Paano kaya process ma-transfer niyan?
Well, you have to execute an extrajudicial settlement, no?
Yes.
Extrajudicial settlement, yun po ang gawin natin. Anyway, I could answer all your questions later in the afternoon. I think
Yeah,
it's
alright.
high time na, high noon, ano? We have to
It's silent and about lunch.
to fill our stomachs.
Later po, no, to be very willing to answer all your questions later on. So, may I call on, yes, parang VP Monet, are you there? Attorney, salamat po ha.
Yes, so
I know you will be very willing to accommodate pa sa lahat ng mga katanungan kasi this is just a bright time for them to ask kasi ang dami pong mga hindi po alam kung ano pong dapat gawin, especially on the deed kasi maraming mga hindi magagandang nangyayari sa mga so may I call on BP Monet? I think Attorney Batloy here is already done.
So I will leave na lang po muna. I'll be back later on po.
Alright,
Thank
Attorney,
you.
thank you.
Salamat. Bye-bye.
Have your lunch.
So, yan po yung lecture ko sa Davao Board. Mamayang hapon po, pag-uusapan natin yung yung titling, no? Tsaka legal expenses. If you want to watch it 1:30 po mamaya, I will continue with our live discussion. Okay, so I will see you soon, guys. Thank you. Bye-bye.